All right, we're live.
Good morning, everyone. Happy Friday. Could we have roll call, please?
Sure. Karen Bell.
Here.
Ruben Duran.
Here.
Gary Farwell.
Here.
Jenna Jones. Jenna's here. Melanie Lawrence.
Here.
Alexia Mayorga. Steve Moab.
I'm here. I believe Alexia is also here. At least I see her.
Sorry, I was muted.
Sure. Okay, great. Cynthia Nakau.
Here.
Ellen Pansky.
Here.
Eloise Rosenblatt. Let's see. Linda Schneider.
Here.
Sean Salig.
Here.
Brandon Stallings. Judge Wang.
Good morning.
And Chairman Lear. We have a quorum.
Great, thank you. Okay, so I understand that we are going to take a matter out of order.
We're gonna, can we ask for public comment first, Chairman?
Oh, sorry. Yeah, is there any public comment?
If anybody in the public would like to speak, if they could raise their hand. And so far, I don't see any hands raised. So I think we can move on.
Great, thank you. And I know for the record that we did have a letter that was submitted for the public comment portion, and that letter, I understand, is part of the public comment record.
And Chairman Lear, we do have two hands raised now. So I guess it just took a second to raise. So it looks like we have Ben. I'm going to unmute your microphone. So if you will unmute yourself, you have 2 minutes to speak to the committee.
Thank you, committee members. My name is Ben Pavone. I'm an attorney and a member of the public. And I'm here to speak briefly just to address what I perceive as a little bit of a disparity between the State Bar's public messaging and what is the ad hoc committee's stated purpose. Okay, and this is mostly in the context of the Girardi scandal, which of course has to unfortunately stay on everybody's mind. In particular, the public messaging from the State Bar, at least per their release on, I want to say June 10th, was that, was sort of this idea that we're going to enlarge the State Bar's regulatory powers in response to the scandal, and we're going to do it by scrutinizing trust accounts. Now, this proposes, sort of the exactly wrong thing, in the sense that, if anything, there has to be an accounting of what was done wrong. There has to be some public transparency about what that wrong is. And then there has to be some sort of committee like this one to assess what we should do. In contrast, the ad hoc committee's discipline committee's purpose, as stated on its website, suggests that it seems to understand that discipline has to be proportionate, and it has a nice statement about its goals and its purposes and that sort of thing. But that now sits in contrast to what OCTC, at least pursuant to its release on June 10th, proposes to do. I mean, the answer to this is not to just start regulating more. It's got to regulate in a way that is targeted to the problems that Girardi represents. Okay, that's my first thing. I know I'm short on time, and I'm sorry to use up so much of your time. The second thing is, to the extent that the committee is proposing to add 4 more members, I'm concerned that that's going to slow down the process. It already has 24 members, and we think, or at least I think as a member of the public, that the sooner the State Bar as a larger organism deals with the Girardi problem, the better for all. So I would oppose respectfully any delays in that process.
Okay, your 2 minutes is up. Thank you, sir.
Thank you.
And now we have Mr. Howard. If you will unmute yourself.
Thank you.
You have 2 minutes.
Okay, thank you very much.
I would like to bring to the attention of your committee the fact that there may be a situation where an attorney can do certain or act a certain way that is not found to be a violation according to your current guidelines, or maybe even the business and code. My situation is very simple. I was an active client. My attorney passed away, and the estate had another attorney contact me and deal with me. And over a period of time, I was led to believe he was representing the trust, and that my legal file would be provided to me, none of which took place. And now I find myself in a horrendous situation where I've been told by investigators from the state bar that it appears that my late attorney took my file to the grave, according to his words. And I think this is appalling, and it's very devastating to me. And I just wanted to bring this up to your attention so that you can look into this and see if there's a way to make this a violation. It certainly is a violation as far as I'm concerned, but I thank you so much for allowing me to. I'm not going to get into any details, of course, because I have filed an appeal to the closure of my complaint, but I would like to try to campaign that this might be an open problem with future clients, because I'm a living proof of what can happen when a licensed attorney can act and make someone reasonably believe that they are being told correct information by the late attorney's estate. Thank you very much. If you have any questions, thank you.
Thank you, Mr. Howard. And Mr. Howard was the one that submitted the written public comment. There is one more person. It looks like Michael Coates. If you would unmute yourself, you have 2 minutes.
Thank you, everybody. My name is Michael Coates. I'm president and founder of Medical Lien Recovery and also Personal Injury Made Easy. And the reason I wanted to address the committee is because I have championed in my company medical providers in the personal injury niche for the past 10 years. And after doing that with hundreds and dealing with hundreds of attorneys, this is truly a broken system. The changes that were enacted in 2018, where ABA's Rule 1.15 was enacted, was great, but it's not going far enough. In my opinion, even with the changes moving the needle in the right direction, we have to do more. Unfortunately, there are some judges afraid to impute fiduciary duties upon the attorneys regarding the medical providers, which, by the way, really impacts the consumer patients, because they're the ones that have to pay what's not paid in the end, and the ones that, if the attorneys don't do their job, the medical provider has to then actually bring a lawsuit to recover that, which none of them want to do that as healers. But that's being forced by too many law firms that when they get a settlement, they don't ask before they have the patient finalizing it about a lien reduction in which they've really based that settlement decision on. And then even when it's all done, they don't want to give whether the settlement results, they don't want to give breakdowns, they want to hide whether they've got more monies to get, they want to hide how much they're getting in attorney's fees or other things. And a full transparency is so important. And if that full transparency is mandated in full, including even keeping everybody informed as to what's going on, because it's the attorney that has the finger on the pulse, not just by where a public filing record is. So I would ask that you really look at enhancing the Rule 1.15 obligations and actually expressly imputing fiduciary duties and encouraging that as upon the attorneys and making them do more than they are, and that they're trying to use the excuse that if it's not literally written in the CRPC,
Mr. Coates,
they
you
don't have to
10
do
seconds.
it. I appreciate that. I'll leave that rest to the committee and happy to expand. I did submit something in writing to you. Thank you.
Thank you. All right, that looks like it concludes our public comment section. Now, Chairman Lear, Ms. Chavez, can you share the slide deck to reorient the committee? And this is the commission charter, just as a brief reminder to the committee that this is what the committee has been tasked with. We can go to the next slide, Lisa, because I want to jump into the topics, but we have covered case processing, recidivism, discipline system metrics in the next slide. The California state audit, the standardization and consistency in case processing. And then we started to do factors impacting case settlement at the last meeting. Next slide. These are some of the areas that at the upcoming meetings that we're going to talk about is more factors impacting case settlement. We're looking at prevention and training materials, and then we're looking at metrics and true diversion in the August meeting. And the final slide, through feedback from some of the members, these are some of the questions as we go through today's meeting that we would like everybody to be thinking about and maybe have discussion on is, should there be changes to the ENEC process? Should more cases settle? And if so, what can be done to increase the settlement rate? Is OCTC charging appropriately? And then what is the state bar doing to prevent attorney misconduct and support those with substance abuse and mental health issues? And are there other things that we could be doing? And then the final agenda item today talks about alternatives to the backlog. And so how does the state bar measure effectiveness, and should there be something else that we should be doing? So with that, I now turn it over to Chairman Lear. I think you're on mute.
I understand that Randy will be giving a presentation now.
Correct.
Thank you. So Randy, take it away.
Okay.
Good morning, everyone. I think Lisa has the slide deck to share. Thank you. Randy DeContorm, Office of Professional Competence. And I'm going to give you a bit of an overview of some of the prevention support resources and even some mandatory activities that the State Bar has that are all designed around prevention of avoidable misconduct. Next slide, please. And I see a lot of familiar faces, so I apologize if you know some of the things I will mention, but I'll try to be succinct. The ethics hotline is the mainstay of the Office of Professional Competence. It is a telephone research assistance service for attorneys. Attorneys can call and present questions about such topics as conflicts of interest, advertising, communication with represented parties, fees, trust accounting. And while the ethics hotline staff cannot provide advice or render an opinion, the staff can provide references to rules, cases, statutes, ethics opinions, other publicly available authorities to assist the attorneys in their further research so that they can reach an informed conclusion as to their ethical issue. The ethics hotline is one of the longest standing programs at the State Bar. It was the first thing I did when I arrived at the State Bar many years ago. And over the years, it has collected much positive feedback, and we do take a demographic survey. So we know a little bit about the usage of the ethics hotline, and I'm going to circle back to the ethics hotline after I survey the other programs. One thing I did want to mention, though, is that questions that involve a pending complaint or a disciplinary matter are not fielded by the ethics hotline. If an inquirer does reveal to us in presenting their inquiry that it's a question pertaining to those issues, the matter in discipline, the fact that they've got a complaint, the ethics hotline staff's State Bar's practice basically is for the ethics hotline to decline to assist in that instance. The Committee on Professional Responsibility and Conduct, known by the acronym COPRAC, is the committee, a standing committee of the Board of Trustees that is assigned primarily to develop advisory ethics opinions. Unlike the ethics hotline, these ethics opinions actually do take the professional responsibility law, apply it to hypothetical facts, and reach conclusions on the particular issues posed. Issues do have to be hypothetical. So when an attorney writes in their question, they can't be asking about the case that's on their desk that day. It has to be a hypothetical issue. And the committee also receives more inquiries and has more topics on their inventory at any given time than they can handle in a particular year. They produce about 5 opinions a year. And in the selection process, they do look for topics that have a wide applicability to practitioners. The opinions are non-binding, and so they don't have the effect of a decision from the state bar court, but they have been cited by both appellate courts and state bar court and used as persuasive authority. The Committee on Professional Responsibility also, and these are not quite ethics opinions, but they also have responsibility now with the sunset of the Committee on Mandatory Fee Arbitration to develop the fee arbitration advisories. And those are primarily for the arbitrators who participate in the mandatory fee arbitration program. But some of those advisories have been, in fact, obtained wider usage. And so there's been advisories on propriety and enforceability of including a mandatory arbitration clause in attorney-client fee agreement. And I've seen that one used sort of even outside the arbitration committee. The Committee on Mandatory Fee Arbitration, again, they sunset, but part of what they did as well is develop the State Bar's sample written fee agreements. Pursuant to Business and Professions Code, State Bar Act Section 6147 and 6148, there are certain circumstances when an attorney's fee agreement must be in writing. Fees where the cost is to be over $1,000 and contingency fees specifically. And to facilitate the compliance with the requirements of those statutes, the Committee on Mandatory Fee Arbitration developed sample fee agreements. The Committee on Professional Responsibility will be continuing to monitor and update those sample fee agreements as needed. Next slide, please. Education. And so the first one is the annual ethics symposium. Each year, the State Bar's Office of Professional Competence with the Committee on Professional Responsibility and Conduct holds essentially a day-long MCLE event, summit, if you will, for those attorneys who are interested in the topic of attorney professional responsibility, which would include, say, the risk management folks at a law firm, the local bar ethics committee practitioners, perhaps respondents bar, folks from the state bar. But the annual ethics symposium has been an event that has been intended to bring those folks together to talk about what are the most cutting edge, if you will, professional responsibility issues. At this year's ethics symposium, which was held completely online, last year's was canceled because it was planned in person and we could not conduct it in person. But this year's symposium was held online. We had 500 registrants, which I think was the maximum. And we had about 400 actual attendees. So it was one of the best attended events. And it is an event that offers this year, at least, free MCLE credit, which is probably why we had a lot of attendees. The new attorney training program is a program that is mandatory. One of the few things that I'll be speaking to today that is mandatory. And it is a program that is part of the general MCLE requirement. Every attorney must complete 25 units of professional responsibility credit every 3 years. And the new attorney training program focuses on attorneys who are newly admitted and imposes on them in particular a special requirement in their first year of practice to complete 10 hours of a specific curriculum. And these are essentially 4 hours of legal ethics, 3 hours of basic skills, 1.5 hours on competency, and 1.5 hours on recognition and elimination of bias. This began for attorneys admitted after February 1st, 2018. And I'll circle back to this program a little bit later as well. But it is a mandatory program. These attorneys must complete this in their first year of practice, or else they go into what would be the MCLE compliance protocol. There's one other mandatory training I'll mention that is in the works. The e-learning module has been completed, but it would be a course for lawyers in the discipline system, primarily probationers, who might be subject to an order to read, quote unquote, the rules of professional conduct. And so when an attorney is disciplined, they're oftentimes ordered to read the rules. And an e-learning program has been created that provides an overview of those rules in an e-learning, distance learning, media-rich, interactive online delivery system to augment that requirement that attorneys in the discipline system, if they are so ordered, are required to read the rules. They would be, once the program is launched, required to also view and take and, we believe, pass a minimum score on the overview of the rules of professional conduct e-learning course. And that would be mandatory, but it would only be for those folks who are actually in the discipline system. One other mandatory education is ethics school and client trust accounting school. And ethics school, client trust accounting school are, I think they've been referred to as the diversion or traffic school for the attorney discipline system. If you are in the discipline system and the matter is not sufficiently serious to warrant perhaps more severe sanctions, you might be referred to take ethics school or client trust accounting school. These were developed many, many years ago by Office of Professional Competence and the Office of the Chief Trial Counsel to provide education and training on the most common areas where attorneys get into trouble. So fee agreements, fee disputes, communication with clients, all of those things are covered in client trust accounting school. Well, ethics school, client trust accounting school was a spin-off that focused particularly on the trust accounting obligations, in particular the record keeping requirements. And those are mandatory, again, for those who end up being diverted to those education programs. It is also available, if you've looked at the background links provided for the agenda materials, it is also available to any attorney who wishes to take it. I don't know how well utilized it is in that regard in terms of voluntary use. I've mentioned e-learning courses a bit. We do have a learning management system portal, which is the entry point to our e-learning courses. We have issued an e-learning course on the topic of new rules of professional conduct. It became operative in 2018. This was the comprehensive revision that cover to cover revised the rules, changed the organization to match the ABA model rules numbering system, and made many substantive changes. And so following the operative date of those new rules, COPRAC held 2 in-person events to provide training in new rules, but we also developed the first sort of voluntary e-learning course on the topic of the new rules. We offered it for free. It was out for over a year. In February of this year, we did take it down, in part because there have actually been rule revisions since the 2018 comprehensive changes. And so we're in the process of making a mini update refresh of that course, and it should be back soon. But the e-learning portal is the foundation for the future of education and training, particularly in the area of professional responsibility, with that same goal of prevention. And I'm going to be speaking to the self-assessment programs towards the end, but the board last year directed that we develop a self-assessment initiative, which is different from normal e-learning, which is just online, media-rich, interactive, distance learning. The difference with self-assessment modules is that the focus is not just on substantive knowledge and tests and knowledge checks on whether they understand substantive information, but a self-assessment module that also inquire into the attorney's actual practices. So where a e-learning course might teach you about client trust accounting obligations, the self-assessment module would do something similar, but the questions asked would inquire, for example, do you notify the state bar when you open and close an IOLTA account? And the goal of the self-assessment aspect of this initiative is really twofold. One, it's to help the learner inform their own gaps in knowledge and implementation of best practices, and also to collect data on the population of attorneys in terms of what those practices are, so that we could use that data to identify any trends in weaknesses in those knowledge as well as practices, and then use that to inform the development of new resources and even new e-learning or self-assessments. Next screen, please. We also have publications that are a mainstay of the Office of Professional Competences Ethics Resources, the Client Trust Accounting Handbook. It used to be a softback book actually sold and distributed. It has since, for many years, become a free online resource in the form of a PDF. And the Trust Accounting Handbook was developed at the time that the board first adopted the record-keeping standards. The rules of professional conduct authorize the board to adopt standards that are used for record keeping, the requirements of maintaining ledgers, journals, and conducting reconciliations. And when those trust accounting standards were first adopted, the Trust Accounting Handbook was published in order to give very practical guidance to those lawyers on how to comply with those obligations. The rules book, publication 250, it's called, has for a long time been the official publication of the rules of professional conduct with selected provisions, originally just from the State Bar Act, but now it has grown to include other selected authorities from the rules of court, from other code sections. And the rule book at present has grown to 2 volumes because of the amount of content. But the one I just showed you is what we've referred to as the mini rule book, which is intended to be more of a portable carry with you rule book. It contains the rules as well as just a few excerpts from the State Bar Act. There's also a ebook version, which is available on Amazon.com of the rule book. And it's cheaper and it's more, in some senses, accessible. And we've been doing that for a number of years as well. The rule book is updated every year because the rules and sometimes the statutes change every year. The compendium index is a feature in the publication called the California Compendium on Professional Responsibility, which is 4 binders of resources. It's in a bit of a transition at this time. We're not sure if it's something that should be continued in its sort of physical form, but the index is really one of the mainstays of the publication. It is a topical index that gives you access to the rules, cases, in particular state bar court cases, and other authorities. It's annually updated, much like most of our other publications, and it's on the State Bar website. Other information on the State Bar website includes dedicated pages on the topics you see on the screen there: trust accounting resources, ethics and technology, civility and professionalism, senior lawyers, judicial ethics. I think there are background links that get to much of these, so I won't expand on it here. If you have questions, certainly respond to those. But the reason why we have an ethics technology page is because we've learned over the years that the issues in ethics and technology aren't limited to specific typical topic areas. So they don't fall necessarily under conflicts. They don't fall necessarily under attorney-client relationship or confidentiality. They cut across everything. And when lawyers are considering utilizing technology in the practice of law, sometimes they need a little help collecting all of the resources on that type of innovation together in one place. And so the ethics and technology page exists to provide that sort of hub for all of those different resources. Civility and professionalism, while not necessarily professional responsibility or legal ethics per se, is also a page that we feel is very important because it gets to the obligation recently emphasized in the revised attorney oath that attorneys ought to be civil in the practice of law. And it includes the civility toolkit, the standards for civility that were adopted by the board some time ago and have been adopted by some bar associations and even some local courts as the civility standards for their attorneys. The senior lawyers page is a page that addresses the issues that arise for our aging attorney population. There is a possibility that lawyers towards the end of their practice may become seriously ill or may die unexpectedly. And so this page is intended to deal with those issues and to provide resources on retirement, disability, and in particular, how to protect the client's interests through attorney surrogacy. And so one of the primary resources is a surrogacy agreement that is been developed by the State Bar in accordance with the probate code that allows, for example, a solo practitioner to designate the person who could wind down their practice or to temporarily take control of their practice in the event that they become sick or they die suddenly. And so way back when, I believe it was one of the board members, William A. Bear, when this program was first launched, he made a point, and there was a Bar Journal article about it, that he was the first person to create his own surrogacy agreement to assure that his clients are protected in case something might unexpectedly happen. The judicial ethics page is this collection of resources provided because there is an intersection between attorney professional responsibility and judicial ethics. Part of it deals with candidacy issues when attorneys become candidates. The other parts of those pages deal with the fact that sometimes attorneys act as temporary judicial officers, and there is a rule of professional conduct that requires those lawyers to essentially comply with Canon 60 of the Code of Judicial Ethics. And so that page is for that intersection of attorney ethics and judicial ethics. Next page. And so we don't have the same amount of information and data on all of the things I've mentioned that we have on the ethics hotline. But we do have some things I want to just touch upon briefly about the hotline, which I think gives us some sort of insight or inference as to both awareness and utilization and efficacy of some of these other activities as well. And so this group is the, I guess, the effectiveness committee of the ad hoc commission. And so I think awareness is necessary for effectiveness and utilization is necessary for effectiveness. And so I want to speak to those briefly. What's on the screen is an excerpt from the In Re attorney discipline case. 1998, the State Bar was shut down due to the veto of the bar's fee bill. The Supreme Court considered the establishment of a regulatory fee to permit the public protection activities of the State Bar to go forward. Deciding the amount of the regulatory fee, the Supreme Court considered all of the various programs that State Bar engages in. And with regard to the ethics hotline and the professional competence activities, it was specifically observed that these programs save the overall discipline system cost by reducing delays in processing some cases by avoiding the filing of additional complaints. And I think in part that is a support for the preventative effect, the beneficial effect of these competence activities, in particular the ethics hotline. Next screen, please. And so I mentioned utilization being important. And I know there was something on the earlier screens about the overarching mission of this particular group. And I saw solo practitioners mentioned. And I think it is important to note that the primary users of the ethics hotline are small and solo practitioners. And it's probably for obvious reasons. These attorneys do not have the support system that larger law practices have. They do not have a management committee with a risk management unit. They do not have an attorney dubbed as the compliance officer. They may not have an attorney in their midst who was a former employee of the State Bar, who I know from some of my former colleagues who go out and practice that if the firm knows you work at the state bar, all of a sudden you become the main person for any question whatsoever that deals with the state bar. And part of it, I believe, is culture. I think if you're in a larger firm, you may not want to go outside your firm for issues of attorney ethics or professional responsibility, particularly questions about things that have already happened and you're unsure if what has occurred might have involved lack of compliance or an outright violation. But the sole and small practitioners, they don't have that system. They may have professional liability insurance, but it might not be sort of the top draw type of insurance where there is risk avoidance training regularly given. And so the ethics hotline and the resources offered by the bar often are the only things for these practitioners. The data here does exclude people who didn't respond to the voluntary demographic survey. It also does not include the people who did not, who basically identified themselves in a practice area such as government agency practice that really wouldn't be relevant to this data. Next screen, please. So I said we'd be looking at sort of the present activities as well as the past and the future. And so looking back now to the past, we did have a program at the State Bar known as the Law Office Management Assistance Program, known as LOMA. It's in 1985. And different from legal ethics and professional responsibility, it was aimed at dealing with law practice management issues. And so if someone were to call the ethics hotline today and say, what's the best case management system that I should use? What case management system will comply with my ethical responsibilities? We really couldn't help them. But that was particularly a question that a program like LOMA was intended to address. In fact, at the time, LOMA was, I'd say, somewhat in vogue because many state bars implemented LOMA programs. I did a quick search this morning. I found a page that listed about, let's say, 15 programs. I clicked on every one of those links and all of them 404, not found. Maybe they just moved to another page, but only one was a Texas State Bar page where they did still have a law office management assistance activity. But our program was in force for a number of years. The services included a hotline and also include fax back service. I don't know if anyone uses fax still, as well as the ability to get educational presentations and to submit your your office for practice audit. By 2008, I was surprised it was 2008, the board determined to terminate the law office management systems program because it was underutilized. And I think, I can't say for certain, that has been the fate of almost every law office management assistance program out there. Again, I only found Texas this morning. Next screen. So I said I'd circle back to the mandatory training of the new attorney training program. And you do have a program which is required, it's mandated. If the attorney fails to comply, they go into the MCLE compliance system. They could be put on ineligible practice status. And you can see that the numbers for the folks who are under the requirement and the folks who have complied. There are some folks who have yet to comply, about 4,000 plus, but their deadline has not been reached. But there are over 1,000 who simply have not complied and their deadline has passed. So they are going into or are already in the MCLE compliance protocol. Next. So I described what we are currently doing, what we have done in terms of LOMA, and the main thing on the horizon for the future is the continuation of the implementation of the board's self-assessment initiative. And so last year, pursuant to a board strategic objective, The format for self-assessment was determined to be an online interactive format. It's not the only format for self-assessments. You could simply put up a printable workbook, or you can use a fillable PDF, but looking at all of the options, in particular the Colorado program, which was largely an inspiration back at a board planning meeting in 2018, representatives from Colorado presented their self-assessment program, which has interactive component, online component to it. And not surprised that that is the format for the state bars programs. And we are in the process of launching the first one. The first one is on the topic of client trust accounting. And we are researching and communicating with vendors. We hope to have that process in earnest, actually engaged in the development of the module before the end of the year. But the future of that program is set forth in an item going to the board at the July meeting that sets forth an Office of Professional Competence 5-year plan. This 5-year plan would take the 10 courses, topics of the Colorado program and use them as a starting point for developing 10 modules for California. These modules would be created as essentially e-learning with a survey component. It would inquire not just about knowledge, but also about practices. We would use that data to inform the development of further authorities. And so there would be essentially a rolling process. We would come out with, say, 2 basic courses or modules every year. After those modules have been out for 6 months, we would review the data, see if there were any trends or inferences that could be gained from it. And if it does signal some particular area of weakness, then new resources, since those can be developed more quickly, such as self-study MCLE articles, or maybe even sort of ethics opinions, those are a little longer create, but we would also be looking at creating new self-assessments. And so the 10 initial self-assessments, again, patterned after the Colorado topics, would be reviewed as they are rolled out. And if they did inform through the data analysis that there are more specific trainings in these very broad basic topics, then in the course of that 5 years, up to 8 more self-assessment modules would be developed to further educate, train, and gather data on those more particular areas. At the same time, there would also be normal e-learning without the self-assessment survey component. And these e-learning courses would be on topics that really wouldn't lend themselves to asking about attorney practices. And so the 5-year plan includes e-learning that would be anticipated to address, for example, the implementation of the paraprofessional program. OPC staff has been working with the working group on the paraprofessional program. They have developed a set of rules of professional conduct, very similar to the attorney rules of professional conduct, that interact with attorney duties, because we do anticipate the paraprofessionals would be collaborating, particularly in legal services organizations, with attorneys. And so we have on the 5-year plan scheduled implementation of an e-learning course that would provide training about that new program if it is implemented, because it will have a brand new set of rules of professional conduct. Similarly, there are things that are on the charter for the Closing the Justice Gap Working Group. For example, changes to the advertising rules, changes to the fee sharing rules from an access innovation standpoint. And there are e-learning programs on the 5-year plan anticipating those things as well. And the self-assessment initiative for me is a major one because I do believe it is one way that you can scale up, if you will, what is the experience of the ethics hotline. Because it's very similar in terms of being interactive and being able to target for the user, the learner, things that are specific to them. So if they get questions X, Y, Z wrong, the automated system logarithm would pump out resources particular to that, which again, not exactly, but replicates the ethics hotline system. And that will be going to the board. for their consideration at the July meeting. And I think that's it. I'm sorry if I went very quickly here. Next screen. The self-assessments will have MCLE credit. That is how we will attract lawyers to participate. Survey activity aren't the types of activities that would automatically qualify for MCLE credit, but because we are developing it, since the board selected sort of an interactive education model for packaging the self-assessment, we believe that MCLE credit is absolutely appropriate in that setting. And the two other things that have been identified as important factors is that the self-assessments will be confidential. We think that there might be lawyers who are reluctant to take the self-assessment absent that confidentiality. Next screen. And I'm happy to
That was
answer
it.
any questions or comments.
Okay.
Randy, thank you for that. I do have some questions. And my biggest concern is the new attorney training program, where you indicated that already 1,000 of the new attorneys are out of compliance. To what do you attribute that? That's a very big concern for me.
Part of it might be unawareness, possibly. I don't really know if that number reflects folks who have been contacted through the MCLE compliance protocol and given an opportunity to come into compliance. I think we could, ARC, our staff probably could provide more finely sliced data on exactly what that 1,000 number encompasses. I believe, but I'm not sure, that it's simply the folks who didn't make their deadline. And sometimes if someone doesn't make their deadline, either they weren't aware or they missed their deadline. As soon as they're contacted, much like normal MCLE compliance, they do bring themselves into compliance before any negative consequence.
And does anybody in the room have a sense as to whether those attorneys who are in non-compliance will be referred into any type of discipline system?
It wouldn't be discipline. I think it would be ultimately an administrative suspension.
Okay, understood. Then I was curious and interested that the law office management program was discontinued, and wanted to ask you, and I think the group in general, as to whether that's something that should be revisited, and whether anybody has the opinion that it failed because it wasn't marketed well enough. But I think that, and probably Ellen would echo this, is that that's exactly where the help is needed. Because when we represent these respondents in the disciplinary process, they're essentially two different camps. One camp would be the attorneys who are not doing well in the courtroom / with respect to the day-to-day client relations, and there are the others that are just their problems stem from not managing their practice as well. And we'll hear over and over about how I'm a really good lawyer, I'm really good in court, clients love me, I'm just not good at the business part. And so to the extent that there's an opportunity for them to use a law office management tool, I think that could be a really nice focus for us to prevent discipline on a future going basis. Does anybody have any comments to that? I see hands raised. Ellen.
Yes, I believe, if I recall correctly, that when MCLE compulsories first were adopted, law office management was one of the compulsory subjects, and that was revoked at some point, which I thought was a mistake at the time. And I do agree with Ed that a high percentage, and I don't know if this is being tracked at all, and perhaps it should be by the state bar, but a high percentage of complaints relate to law office management related issues, including communication. We've already talked about, management of the client trust account, which by empirical data often is a bookkeeping problem rather than a misappropriation of funds problem. So I think that would be a good area for the state bar to renew attention and resources on. I have another comment, but I don't know if you want to come back to me after this topic is completed, Ed.
I'll come back. Jenna?
Could we, I'm just asking, what kind of relationship do we have with the law schools? Could they incorporate something into their curriculums to address these issues? Especially if you have a lot of new licensed attorneys that are already in non-compliance.
Randy or Leah?
Yeah, we have a strong relationship with the law schools, particularly those schools that we accredit. So those are the California accredited and the registered schools. And certainly that is a recommendation that could be brought forward.
Thank you.
And Randy, I have another question for you. I was interested to learn about the training for the probationers, or the course for the probationers regarding the rules and taking the course regarding the rules. My question is, how is that different from the already existing ethics school?
The ethics school is intended to be, and has been from the beginning, and we have Melanie and Steve here, a situation where you actually have the lawyers in the room with the instructor. I was privileged to be one of the very first ethics school instructors many, many years ago. And it's sort of an exercise in overcoming their the wall that they put up by having to be forced to be in that room, and demonstrating that this activity, the ethics school activity, even though they're being forced to take it, is intended to help them. And what you find, there was an article in the Cal Bar Journal, you can look it up, I think Robert Henderson was the featured person there, but you have some excerpts from some of the feedback on ethics school, and it's consistent with the feedback I received way back when. And that is, many lawyers say, if I had the opportunity to learn this information, to ask questions to truly understand how this works, years ago, I would have never gotten into trouble. And there also are comments that you get back in ethics school that I think this should be for everybody. And I think part of that is the dynamic that occurs in ethics school, where, for lack of a way of describing it, the instructor wins over the audience to realize that the bar can be of assistance and can be helpful. It's not just out there to slam you, it's out there to facilitate your compliance, to keep you out of the discipline system. And so the read the rules requirement that comes up in the discipline system, that was very sort of passive. You issue an order, they say they read the rules. Hopefully they did. Not sure if they actually learned anything, but the e-learning course that would complement the read the rules requirement would have a test component to it. And that test component would have a passing score. So that would be telling the system, the discipline system, whether that person had some understanding. The reason why I think it's not a substitute and why it's different from ethics school is that when ethics school goes back to being in person, I think there's still some of that dynamic online. Goes back to being in person, I think you will be able to, and it's really a recidivism issue. If those attorneys are, again, as I say, won over and they don't treat the bar as something to keep at arm's length. I'm never speaking to the bar unless I'm forced to speak to them. All I do is pay my bar dues and keep them out of sight, out of mind. If you change those lawyers to become lawyers like the users of the ethics hotline who say, I think the hotline and the resources at the bar are helpful, I'm going to use everything they have to offer, I think that is a benefit to prevention. So I'm a big supporter of ethics school. I think the e-learning course in the probation system will help, but I think the ethics school should be here to stay.
Okay, and let me just explain to everybody that may not be aware of this, but in virtually every disciplinary action, there's a requirement through the probation that the respondent take ethics school. So that's a non-negotiable. I'm in favor of that. I think it's fantastic. I'm also in favor of every lawyer in California going to ethics school. But that said, my question is a little different. My question is, what is different about the read the rules course for the probationers that they wouldn't otherwise get in ethics school? I always understood ethics school to more or less be a review of the rules. Maybe I'm just misunderstanding.
I think the curriculum is largely the same. I think the last time I looked at it when we were planning the content for the new attorney training was very similar to what was originally created with OPC and OCTC. And it is talking to the topics, and those topics involve the rules. The rules e-learning course is more of a comprehensive survey. It sort of takes you through the entirety of the rules and tells you what's there. And another important function of the probation course is that it's not just the rules, even though the requirement is read the rules, there are certain selected state bar sections as well. And one of the things we've learned over the years in OPC is that a lot of lawyers just think everything is self-contained in the universe of the rules of professional conduct, which it is not. You do have to look beyond the rules, the State Bar Act, the rules of court, rules of the state bar, and other code sections to really encompass all of your professional responsibility obligations. And so the rules course is, I think, more of a survey of the topics and the rules themselves versus a targeted effort, which is the outline in ethics school, focusing on the things that get attorneys into trouble.
Great, thank you. I'm turning to Ellen. Ellen, you had a comment.
Actually, I have a comment and a question. I think another resource that the State Bar is offering, which we haven't touched on yet, is the succession planning and the sample succession contract that the State Bar has approved, or perhaps it's being revised. But in any event, I think it goes to the issue that Eloise has raised on several occasions and that our public member touched on this morning, which is we have an aging population of lawyers. We've got a significant proportion of our bar membership who are solo practitioners or small firm practitioners. And when a lawyer becomes incapacitated or dies, it's a real problem, and it presents a problem for OCTC, I know. And for those of you who may not be aware, there is a provision in the Business and Professions Code where any lawyer can go in and petition the Superior Court to take jurisdiction over a lawyer's practice if the lawyer is deceased or incapacitated. The State Bar can do it, but it could also be a friend or a volunteer. And I regularly get calls from spouses or children of deceased lawyers who don't know where to turn. And I think that we should also be promoting, the State Bar should be promoting the resource that it's already developed for a succession plan. I think a lot of lawyers are completely unaware of it. And I suspect, although I don't know anything about the individual case that was presented this morning, I suspect that what may have happened there is that a volunteer stepped in to try to locate client files and provide them to the clients of the deceased lawyer, which of course is completely different from representation of the decedent's estate. And it may be that the file simply is not available. But again, had there been a succession plan in place, then there would have been a lawyer who was already committed to and prepared to transition files from the deceased lawyer to the client or to some other lawyer. So I think that's another really important piece that we need to include in this presentation.
Eloise.
Thank you. Ellen, I want to follow up on that. I actually made a recommendation to a senior attorney friend of mine after she had some health issues. I said, really, don't put yourself in the position of having the state bar to, having a client complain. So what she did, she took me seriously. I said, the state bar has resources, and she did find and emailed to me the resource that I didn't know existed. It's a kind of a DPA, durable power of attorney, if you will, for the case of an attorney who may be anticipating healthcare concerns, but it is a form of assigning a power to another attorney to step in case
Is it just me or did we?
Yeah, I think we
it
lost.
froze.
Okay, all right.
Yeah, Eloise, you froze. Okay, we'll go back to Eloise. Does anybody else have any comments? Oh, Eloise, you're back.
Okay, I'm trying to pinch hit with my iPhone. I lost internet connection this morning. I apologize for not being able to get on, but it was beyond my my powers and evidently the power of AT&T. But what I wanted to just affirm briefly is Ellen Pansky's, the importance of Ellen Pansky's calling to our attention the resources that do exist. I didn't know what they were, but there is as I say, effectively a durable power of attorney by which an attorney who anticipates that there may be health problems, coming or is going to need some help, assigns some other attorney the power to take over that practice.
Great, thank you.
Let me just mention that was the resource, the featured resource at the senior lawyers page that I was referring to. I think it's because I call it attorney surrogacy as opposed to succession plan that might have been overlooked, but that is the program that former board member Bill Hebert tried to publicize by making himself the first person to enter into such an agreement with another lawyer in another firm to cover for his practice in the event something happened to him. Let me mention on that topic, if that is something of interest, that some jurisdictions have gone the route of adding to their rules of professional conduct requirements concerning succession planning. And the Rules Revision Commission did consider that as a possible rule to add when we were doing the comprehensive study of the rules of professional conduct. It was considered, but it was not recommended for adoption for two reasons. One was the concern that it might have a disparate disciplinary burden on only certain attorneys. Only those solo attorneys who didn't already have a partner or an associate to pick up the practice if something happened to them. And so it would be a rule with a disciplinary consequence primarily for solos. The other concern was if you put in the rules of professional conduct, lawyers shall have a succession plan, and a lawyer doesn't comply, and it's because they died or are in the hospital, is that the person that the state bar is going to go after and discipline? You can't discipline a deceased attorney who didn't comply with the rules to have a succession plan. And so while the rule is something that might be considered, I think the Rules Revision Commission decided against it for good reasons.
Good. Any other questions or comments? Seeing none, great. All right, thank you, Randy. That was very thorough and insightful. Really appreciate that.
Thank you. I'll leave now. Thank you.
Thank you. Okay. Justin, our next topic is...
We can go back to the beginning of the agenda where we will talk about moral turpitude and the factors that impact case settlement. And Rachel Grunberg is here.
Let me get us up and running here. Whoops. Sorry, let me just close out here for a second.
And just so you all know, that the schedule generally is to go till about noon, take a quick short lunch break for about 20 minutes, and then wrap at around 2:15.
Okay, great. Okay, so Justin, before we get started, I just want to say for the topics for today, we're to focus on factors that impact case settlement, prevention support resources for attorneys, and then a discussion about alternatives to the backlog. As you saw, we took a little detour and heard one portion of the presentations on prevention. So now we're going to get started on our factors that impact case settlement. And we're going to start with an overview of discussion of moral turpitude. We have Rachel Grunberg here, senior attorney at OCTC. I'll be sharing some research that we've started on this topic. And then after that, we'll open up to discussion in the same format as we had last time, where we're going to hear from OCTC, Melanie and Steve, as well as Judge Wang and Ellen Pansky on this topic. And after that, we will hear from Ed Lear, because Ed, last time you mentioned wanting to bring back ENC to talk about, in particular, is it an option for criminal convictions? And then after that, I can share some other research we're doing. Okay, so let's get started. Rachel, go ahead.
Good morning. Thanks for having me back. My name is Rachel Grunberg. I'm a senior attorney in the Office of Chief Trial Counsel in the San Francisco office. Been with the bar about 22 years. I was with the Office of General Counsel for 17 years. I was then with the State Bar Court in the review department for a couple years. And now I've been with trial counsel for the last 3 years. So I have a pretty comprehensive background here at the bar, being in all 3 legal units of the bar. And I think that that lends to this topic on moral turpitude. And so I'll segue into that now. Being an attorney requires more than demonstrating knowledge and mastery of technical skills. Attorneys must also demonstrate good moral character, and the commission of acts manifesting moral turpitude can result in attorney discipline or license revocation, even if the attorney's professional competence is not disputed. So what are these concepts of moral character, moral turpitude? What do they mean? When we say an attorney is expected to demonstrate good moral character, it means they must demonstrate traits of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibilities, respect for and obedience to the laws, and respect for the rights of others and for the judicial process. Acts of moral turpitude, on the other hand, are generally seen as the antithesis of good moral character and include a wide range of deceitful and depraved behavior that is deemed contrary to the rules of morality and the duties owed between people or to society in general. Now, there are other professions where these concepts are not necessarily part of the calculus or imbued in what they do, but in our profession, it is. The paramount purpose of the moral turpitude standard is not to punish attorneys, but to protect the public, the courts, and the profession against unsuitable practitioners. The definition of moral turpitude is not defined with any precision. In fact, our California Supreme Court has said it cannot be defined with precision. And yet the courts have consistently said that it is not so vague as to be unconstitutional. So it brings to mind the phrase, "I know it when I see it," which was used in 1964 by United States Supreme Court Justice Stewart to describe his threshold test for obscenity. One of the reasons that moral turpitude lacks precise definition is because it's not a concept that is stagnant. Rather, the concept of moral turpitude can evolve depending on the state of public morals and may vary according to the community or the times. So for the purpose of illustration, there was a time in the not so distant past that domestic violence was not viewed as seriously as it is today. During most of the 1900s, domestic violence was acknowledged, but treated as a private family matter. As the years progressed, domestic violence began to be seen as a violent criminal act. And as the attitude toward family violence and domestic violence began changing, so did the criminal justice system and the penalties associated in that arena. And today, domestic violence is acknowledged as a very serious criminal matter. On the other hand, there was a time that marijuana use was considered a serious offense. Now it's legal in California and in more and more states around the country. There was also a time that homosexuality was seen as criminal or depraved, and of course that has evolved and changed too. So again, the concept of moral turpitude changes over time and evolves. Sometimes the Office of Chief Trial Counsel will pursue a theory of moral turpitude to establish new case law on whether something involves moral turpitude. Domestic violence, some of the respondents counsel in the room may know that this is an area that we've been exploring. We may not have prevailed necessarily on the per se element, and I will talk about what a per se moral turpitude crime is in a minute. But in cases where the facts and circumstances demonstrate severe violence or other acts of moral turpitude, we will explore that because, again, this is an area that is developing. Notably, whether misconduct involves moral turpitude is a question of law to be determined by the court. So these issues often need to be litigated, and that affects settlement. So I know that's one of the focuses you're here to discuss today. Because of these issues that I just identified, the lack of clear and precise definition, the fact that it's a matter of law, the fact that these are evolving standards, this makes cases involving moral turpitude some of the more challenging and contested cases that we deal with. Notably, when we're litigating or looking at these issues, we look to relevant statutes and case law for guidance. Generally, when we charge an act of moral turpitude, we charge it as a Business and Professions Code Section 6106 violation. And I'm going to read it to you. It says 6106 says the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, and whether the act is a felony or misdemeanor or not, constitutes cause for disbarment or suspension. Some of the more common disciplinary charges involving moral turpitude that our office brings, misrepresentation or misappropriation. Those are probably the two most common charges that we bring. Other areas might include habitual disregard of client interests, overreaching, UPL, that's unauthorized practice of law. There's an element there of dishonesty when you're knowingly holding yourself out as entitled to practice law when you're not, things of that nature. So these are the most common types of allegations that we can bring and that we do bring. Notably, culpability can be established for a charge of moral turpitude by showing intentional acts, but also culpability can be established through gross negligence. So for an example, if an attorney signs a declaration under penalty of perjury without verifying the information in that declaration, that can be seen as a grossly negligent act. Similarly, failure to properly oversee and manage a trust account, resulting in overdraft activity or deprivation of client funds, can be seen as grossly negligent misconduct. Again, important to point out the statute which I read said that the acts of moral turpitude are not limited to acts committed during the course of law practice, nor is a conviction required. So what happens in an attorney's private life is also an area where the State Bar can explore charges of moral turpitude. There are criminal conviction matters, though, that do result in referrals to the State Bar Court. And in the criminal area, we have moral turpitude per se crimes, which I alluded to earlier. Moral turpitude per se crime is a crime where the conviction in every case evidences bad moral character. These crimes generally involve an intent to defraud or intentional dishonesty for the purpose of personal gain. So crimes like forgery, embezzlement, robbery. They may also include particular crimes that are extremely repugnant to accepted moral standards, such as murder or serious sexual offenses like rape. Again, just to reiterate, these crimes are not limited to crimes committed during the course of law practice, and a lawyer's private acts or criminal acts can also result in disciplinary proceedings. So there's this seminal case in Ray Lazansky. This was the case where an attorney was engaged in criminal misconduct. It was not related to the practice of law. And our Supreme Court looked at whether or not they would be subject to disciplinary action. And the court set forth a test, which we look to now as the seminal test regarding whether crimes committed outside of an attorney's law practice will subject them to moral turpitude findings. And this is the test that they announced in Ray Lazansky. Criminal conduct not committed in the practice of law or against a client reveals moral turpitude if it shows a deficiency in any character trait necessary for the practice of law, such as trustworthiness, honesty, fairness, candor, and fidelity to fiduciary duties, or if it involves such a serious breach of a duty owed to another or to society, or such a flagrant disrespect for the law or societal norms that knowledge of the attorney's conduct would be likely to undermine public confidence in and respect for the legal profession. So that's in Lazansky. The court held that an attorney's conviction for attempting to commit a lewd act on a child of the age of 14 or 15 years old and at least 10 years younger than the attorney necessarily involved moral turpitude, and the attorney was summarily disbarred. So these per se crimes are distinguished from crimes where the facts and circumstances may involve moral turpitude. Those are also an area that I know respondents bar and others are interested in. An example of this might be a DUI offense, for instance. It's not a per se crime. Drinking and driving doesn't necessarily involve an element that's per se moral turpitude. But when we look at the facts and circumstances, which will include the police report, statements from witnesses, victims, law enforcement, etc., there may be other acts of moral turpitude that are involved. For instance, potentially there might have been hit and run activity, serious misrepresentations to law enforcement, etc. We've had DUI accidents and offenses that have resulted in very serious bodily injury or death, those kind of situations. Another example might be, for instance, say we have a trespass conviction. But when you look at the facts and circumstances, the attorney may have pled down to the trespass conviction, but really we see that there are potentially like peeping activities or other activities that may implicate moral turpitude. Those are things that we explore in the Office of Chief Trial Counsel, and that are instances where we may bring allegations of moral turpitude. Committing an act of moral turpitude is a serious offense, and the sanctions accordingly call for significant discipline. Like I said, the statute itself calls for suspension or disbarment, and our sanctions accordingly track that language. So if you look at all of the various sanctions, you'll see that they call for disbarment or actual suspension. If you look at standard 2.1, which deals with misappropriation, you'll see that the presumed sanction for intentional misappropriation is disbarment. Of course, there's language in the standard that talks about how it can potentially be mitigated down, but that's the presumptive sanction. Again, that same standard talks about what the presumed sanction is for grossly negligent misappropriation. Again, it calls for actual suspension. That we have a catch-all standard, standard 2.11, that deals with moral turpitude offenses in general. Again, it calls for disbarment or actual suspension, and it does give guidance on how to evaluate where in the range the misconduct might fall. I'll read it to you. Disbarment or actual suspension is the presumed sanction for an act of moral turpitude, dishonesty, fraud, corruption, intentional or grossly negligent misrepresentation, or concealment of a material fact. The degree of sanction depends on the magnitude of the misconduct, the extent to which the misconduct harmed or misled the victim, which may include the adjudicator, the impact on the administration of justice, if any, and the extent to which the misconduct related to the practice of law. So there's built-in factors there that we can analyze that help us determine where on the range the appropriate discipline should be. In terms of the criminal arena, we have separate standards for that. Standard 2.15 discusses criminal convictions involving moral turpitude. Again, disbarment or actual suspension is the presumed sanction for misdemeanors involving moral turpitude. And summary disbarment is the sanction for felonies involving moral turpitude. And some of you may know that the statute, Business and Professions Code Section 6102, was recently amended so that summary disbarment is now not only the appropriate disposition when there is per se crime involving moral turpitude, but also when we have a felony where the facts and circumstances demonstrate moral turpitude. So this is sort of an overview. I know moral turpitude is a very complex topic, and I'm sure there's lots of questions. I think the takeaway, though, is that it is complex, it is challenging. For that reason, it's probably one of the harder counts to settle, because it is challenging because there is no precise definition, and because it is a question of law, so often it is a question that the court needs to decide. So I'll open it up for discussion if anybody has any questions. Again, this was just a brief overview. I could speak for days on this topic, but I just wanted to give you a flavor of what moral turpitude, what it involves, and what are some of the more common disciplinary charges and sanctions for acts of moral turpitude.
Thank you, Rachel. I'm just going to interject on behalf of Ellen and me real quickly that there's another side to this too. And the other side to it is that for our clients, moral turpitude is the scarlet letter. And the way that the system works generally is that when you stipulate to moral turpitude, or there's a decision that involves moral turpitude, that is a decision or stipulation that goes on a respondent's record, membership record for life. And so the reason that it's hotly contested is that it's really hard, I think, to get retained by a new client who's looking you up and sees on your membership record that there's been a finding or a stipulation to moral turpitude. So I just want everybody to keep that in context when you're making your comments and whatnot. The moral turpitude is bad. We get it. Dishonest and corrupt practice is bad. But remember as well that moral turpitude also includes gross negligence. And so that when we're negotiating on behalf of respondents, as much as possible, we try to negotiate for gross negligence. If the moral turpitude if it's non-negotiable and the client wants to settle, because the optic on that is very different than dishonest or corrupt practice. So does anybody have comments or questions for Rachel? Ellen.
So I've mentioned before that the issue of the charging of moral turpitude is a major impediment and cause of delay in the system. And I do think that this topic deserves a deeper dive in terms of the processes that are being used to charge moral turpitude. I am waiting for the statistics. I know that staff is in the process of gathering statistics, but anecdotally, I've done an informal survey among members of the Association of Disciplinary Defense Counsel, and it appears that moral turpitude is overwhelmingly charged in the vast majority of cases. And that certainly is a departure from the traditional way of charging disciplinary offenses. Typically, if a lawyer has engaged in conduct that does not involve dishonesty, that does not involve a criminal offense, there has been some violation of a rule of professional conduct, moral turpitude traditionally has not been charged, and now moral turpitude is being charged routinely. And as Rachel pointed out, if moral turpitude is charged, then staff looks to standard 2.11 and then wants to impose or negotiate a higher degree of discipline. So it's kind of a bootstrap situation. If you've got an underlying violation of a rule and there's no moral turpitude involved, then the degree of discipline that the lawyer should receive for a fair and just result is going to be lower than if there's a moral turpitude charge included. This is a primary reason why cases do not resolve, because as Ed said, lawyers are not willing to stipulate to moral turpitude. I would disagree if there was an inference, and perhaps there was, and perhaps there wasn't, that gross negligence requires a finding of moral turpitude. That is not what the state bar case law provides, nor should it. Typically, in order for there to be moral turpitude, there has to be some additional level of wrongdoing, which typically is either, you know, a serious intentional offense or a criminal offense or an element of dishonesty. It should not be, and it is not, that if a lawyer is grossly negligent, say, in failing to conduct proper trust account record keeping, that should be the type of gross negligence that requires a finding of moral turpitude. It's sort of a crossover issue to a topic we're going to address later, which is the settlement process. And I want to call back to something that Judge Wang said at our last session, which is that if we want to deal with the problems in the system, and that is the mission of this commission, is to look at where the system is not working, then we have to look at why cases are not settling, why solo practitioners and practitioners of color are having a worse outcome in the discipline system. And a big part of that is, I believe, that those lawyers do not have resources. They either cannot afford representation or they don't know how to get representation. They don't know how to educate themselves about what the disciplinary case law provides, and they don't know how to effectively represent themselves. And they end up stipulating or defaulting and having a worse result because they simply cannot navigate the system, and that's not right. And we need to fix this problem. And one way to do it, I think, is to take a careful look, and hopefully the statistics will help us, as to how many cases include a moral turpitude charge, how many cases are being resolved with a moral turpitude finding, and how many of the cases that end up with a moral turpitude finding are lawyers who are not represented, and or who are Black male lawyers, and or who are solo practitioners who are not represented and just stipulate or default. And in my mind, this is one of the most important topics that the commission needs to analyze.
Thank you. Alexia.
Hi, everyone. Just to echo first Ellen's comments, I think this is something that we've seen in every meeting that we've had, this issue of unrepresented people. And I know we've mentioned before the idea of providing representation or low-cost representation options. So I know that's already out there, but I think that's extremely important. My question, and I'm sorry if I missed this, or if this is not the appropriate time to talk about it, it might be during the next issue, but is, once a moral turpitude finding is stipulated to or found, is there anything like in the criminal system where you can get a 1203.4, some sort of dismissal or expungement of that? Because I know at the beginning, I want to say a couple of months ago, we got a public, I think it was a public comment of a gentleman who indicated he had some sort of finding on his record, and it was making it very hard for him to find a job. And so I don't know if there's a process to do that, or if that's something that is maybe an idea to put out there that could help in negotiations and also stipulations to say, okay, if you're, on this probationary status for 1 year, you'll get reduced to something that isn't moral turpitude or something along those lines.
Rachel, you want to cover that?
Yeah, we currently, we don't have an expungement process for any public discipline. It's part of your permanent record. It remains part of your permanent record. So I will say, from the Office of Chief Trial Counsel, we understand that moral turpitude is a serious accusation, it is a serious offense, it does follow the attorney. And we are very conscientious of that. So we bring those accusations, you know, when we've done the investigation and the analysis and we think it's there. But I understand that these are the cases where I think most of the litigation, I think if you were to also run the numbers, these are the cases that are the most highly litigated. That's just the reality. They carry the most severe penalties, again, the most severe consequences, they are litigated, but we are bringing them only when we feel they are righteous cases. Again, we can disagree. I mean, you can even see when you read the state bar court decisions, often the hearing department and the review department will disagree, or the Supreme Court will disagree. The problem is moral turpitude in general is just this very fluid concept that sometimes carries with it, you know, ideas of morality, which can differ among different adjudicators. Unfortunately, that's the issue with moral turpitude. It's not a fixed and stagnant concept. So these are the more difficult cases. They are the more challenging cases. They are the more contested of the cases that we bring. That's just the reality. I think it is natural that they are going to be harder to settle. So I share that with the group.
Alexia, I want to point out that the subcommittee on fairness is discussing the same issue at their next subcommittee. With the effectiveness is kind of, are we being effective? Are we using our resources effectively? Fairness is looking into the issue of, you know, what we do with complaints that have been closed with no action. And then also, because they are, you know, state bar or Supreme Court decisions, there is no process for expunging, but maybe we take a different tact on what is on the website, like what goes on the attorney's profile. Those are the types of issues that fairness is going to discuss at their Monday meeting. So it is being discussed, and anything will be brought back to the full commission in September.
I have a comment. Forgive me for not having my video on. The California Association of Black Lawyers sent out a survey to attorneys, and I just want to read one of the responses. The responses were all anonymous. One person responded that the charges included multiple claims of moral turpitude and fraud, which were without merit and eventually dismissed after 2 years. The bar court judge at the mediation was the most fair stage, and she, a Black judge, for the first time said the prosecution's case was weak and overreaching and should not result in a license suspension. After that mediation, the prosecutor eventually agreed to probation and dismissed all but one of the excessive charges, which never should have been filed. So there's a case where it sounds like the moral turpitude claim was unnecessary, but as the staff has said, it's the most serious factor. And again, this is a Black attorney who was dealt with unfairly in their estimation, because the staff chose, the Office of Chief Trial Counsel chose to vigorously prosecute a weak claim of moral turpitude against them. Just wanted to make that comment, and because, you know, we need to deal with what is really going on rather than what's on paper.
Thank you, Gary. Linda, you had your hand up earlier.
I did, and then Ellen was talking and she sort of answered my question, and I was curious about statistics on, you know, the frequency with which moral turpitude is charged, how often the cases settle and how often they go to trial, to put it in some perspective. So I understand from Ellen's comments that the State Bar seems to be working on getting that information.
Hi, everyone. Can I answer that? Yes. Hi, everyone. Good morning. This is Lisa Chavez, the Director of Research at the State Bar. My staff recently conducted an analysis on this very topic. We were all set to share results answering all the questions you just asked, but it needs to be reviewed one more time. We've discovered some significant nuances in the data, the State Bar court data in particular, that my office isn't completely, we usually analyze OCTC data, and this data we're analyzing the State Bar court data, and given the transition to Odyssey, et cetera, new data systems, we just need to do one more final check of that data. And we are confident that we'll be bringing some analyses to your next subcommittee meeting. Thank you.
Melanie.
No, actually, I was just going to see if there could, if we could share some information about the statistics and when they would be coming, because I know that, you know, and I've certainly heard the comments that there's a feeling, or that there have been some surveys or informal surveys that have been done, but I really think that we need the actual data to know. It's my belief, as Rachel shared, that, you know, we go forward on charges when we feel like we have sufficient evidence to prove them. And yes, they are very serious charges. On the flip side, if an attorney is engaging in acts which constitute moral turpitude, they are a risk to the public. And clients who are shopping for an attorney should know who they're getting. And so, you know, I just want to make sure that we're clear on where we are in terms of the data. So I'm interested to actually see it when we have it.
Thank you. Any other comments?
This is just a question actually for Justin and Lisa. I had thought we were going to sort of directly engage this group on identifying the desired scope of the research, the metrics.
Sure. I have a slide on that. Why don't I go ahead and, whoops, sorry. Okay. So these are the research questions that are guiding the current project. One is, how often does OCTC file moral turpitude charges in State Bar Court? How often does State Bar Court dismiss moral turpitude charges? And how does this compare to the extent to which they dismiss non-moral turpitude charges? Where you will take a step back and compare cases that have a moral turpitude charge compared to those that don't. We'll answer questions such as, how long did it take to settle? What other types of charges, how many charges in total, comparing the two different types of cases. We already have explored if we can answer the question, does moral turpitude charge impede settlement? And we've discovered that we do not have, unfortunately, the data in the database to answer that question. In order to answer that question, we would need to have in the database what charges were presented to the respondents at the time of offering an ENEC. And unfortunately, that data at that point in time, even though we have charge data, of course, in our databases, that's a specific point in time that we've identified that we wouldn't be able to identify. So if anyone has any other suggestions on this analysis that we're conducting, we're happy to hear it.
I just have one other comment in terms of, does a moral turpitude charge impede settlement? And also with, you know, do these charges get dismissed? There are affirmative defenses to moral turpitude charges. And sometimes these do not get developed until trial. So we go forward with these charges. We don't necessarily know the respondent's position. They may deny it. They may say, you know, whatever, but the actual affirmative defense to the allegation is not developed. Again, it's a question of law. It needs to be litigated. So as Melanie said, these are serious charges. When we have complaints of types of dishonesty or very serious misconduct where we bring these allegations, sometimes they need to be litigated and sometimes we lose, but I don't know that there's a translation there exactly that they were brought unjustly. Again, they are the more serious allegations. And so in any arena, the more serious allegations, I think if you were to do an analysis or data comparison, those are the least likely cases to settle, whether you're dealing with in the civil arena or to the criminal arena. So I think that it's natural that the moral turpitude cases go through, more of them go to trial. That would be my, without seeing any data, that it's just what happens in reality when you're talking about the more serious allegations. People don't want to settle with it. We think it's serious, so we want to pursue it, and so we go to court over it.
I don't want to jump the line because I see a number of hands raised, but I also realize that as a host, I don't have a hand to raise. So let me just say one thing, because it draws directly on what you were saying, Rachel, and then I'll apologize and yield the floor. But I think this gets precisely to the analytic challenge of assessing this question of whether or not a moral turpitude charge impedes settlement and draws out a case. Given the seriousness of moral turpitude charges, you would expect these cases to take longer. Whether they take longer because there's, the imposition or the charging of moral turpitude where it doesn't belong is another question altogether. But one would expect to see these cases take longer simply because of the greater severity of the cases.
Thank you. Judge Wang.
Okay, I agree with most of the discussion this morning. It's complex, and I just want to frame the issue for people who are not in the system. I think we've hit a lot of topics, and I think Ms. Bell mentioned this last time. Why are we talking about it? And again, I think everyone should have the shared goal that we need to address the bad actors and protect the public. So what is impeding that ability? And that's why we're talking about some of these topics that impede settlement, because the matters that can settle early and settle and clear up the backlog, that's what we're addressing. And so when we're taking on this piece of moral turpitude, it is very amorphous. And I think the Respondents Council, their theory is overcharging, and OCT's perspective is we need to go after bad actors. And as the independent arbiter of all of this, is both things are true at the same time. So the question is, what recommendations can we make? Where can we move forward from here? And I don't have an answer for that, but I think more information needs to be given to the people who are not part of the system. So when we're looking at moral turpitude, and Ms. Grunberg and Rachel had explained this, it's a catch-all. So when Respondents Council is saying that this is overcharging, that may not be an accurate term. There may be mischarging. So when a hearing department judge throws something out, they may see a different misconduct that's more appropriate. And an example would be the misappropriation. So if there's a CTA issue, that's addressed by the rules of professional conduct. So you might see a dip. We see a dip. So certain amounts are supposed to be dedicated to the client, and that number is not maintained in the CTA. So that's going to be a dip, and by definition, misappropriation. So defense counsel may see, well, this should be a CTA violation. So we may be looking at a 1.15, so this should be reproval. OCTC is going to say the facts and circumstances, it's going to show that there was gross negligence involved, or it was intentional. So we're going to go after misappropriation. So things shake out at trial, and it's the challenge in settlement is, well, what are the true facts? What are the credibility calls? Because a lot of this might just be credibility, and you can't see that until you go to trial. And that's why it kind of needs to be appropriately addressed. And I don't know what the easy answer is, or if there is even a hard answer to it, but I just wanted to put all of that in perspective, because I think, some of you folks rightly are lost in this discussion. So I just wanted to put that out there.
Thank you. Sean.
Yeah, so so this is an interesting discussion. Well, as Judge Wang said more articulately than I can, you know, I've been hearing this debate for years. OCTC says we don't overcharge moral turpitude. The defense bar says, yes, they do. So I think, as Judge Wang said, some cases are just going to be cases where reasonable minds can differ, and they might have to go to trial for all the reasons she described. But at the same time, I think we need to do something to make some progress on understanding this issue at a systemic level. I think it is one of the most fundamental issues in front of the commission. And I have been asking literally for years for this data to be produced. So I don't think we can accept the answer that the system doesn't allow us to do this study. We have to be more creative about a way to do that. Leah had a number of years ago was going to have a manual study done because we knew the computer system didn't have the data, and we had the old computer system in place at that time. So I think we need to look at, that's obviously labor intensive and not the funnest project for whoever has to do the gut work, but I think we've got to do something to get this data. And maybe it's picking random months you know, for the last 5 years and just going through the data for that month, or there's some way to take a sample instead of looking through everything. The second idea I have, which is a new idea, just listening to this discussion, is if the if both sides, OCTC and the defense, is to make a list of the cases where you think the facts did not warrant a charge of moral turpitude at the charging stage. And you can always talk privately to OCTC about particular cases with names if you want to get the perspective. But one way or another, bring to the commission some examples of fact patterns where you think moral turpitude was charged and it shouldn't have been. Because going back to the big picture of things, I'm certain that it's really not that everyone would agree if there's a moral turpitude charge in the case, it's going to be harder to settle. And so if there are moral turpitude charges that are being made because that objective people would look at it and say that's overly aggressive, then that's something we should look at. That's one of the most fundamental issues with the system that's been raised for year after year. So I just think one way or another, we've got to find a way to make some progress on understanding this issue in a manner other than anecdotes, because all we have now from both sides is anecdotes and opinions, and we don't really have any hard and fast data to consider.
Those are good comments. I'm going to add a little color to this, and that is experiences that I've had with many clients where the dispute is over the moral turpitude charge. So OCTC takes the position that we will not negotiate down moral turpitude. My client says, well, I can't stipulate to moral turpitude. That'll be the end of my career as I know it. And so it's bet the company litigation. And indeed, those are the ones that go to trial very often. And so at least an idea that I hadn't thought of before, but just throwing it out there now, if the purpose of what we're doing here is effectiveness, and if what we are trying to accomplish is resolving those bet the farm type of cases, is this something that where we need to make a recommendation or a request to the legislature and say, well, let's promulgate a law that is moral turpitude light. And by that, I mean, something that's not called moral turpitude, but essentially satisfies all sides here. So it would enable a respondent to stipulate to a violation that wouldn't be the scarlet letter, and that it would accomplish the purposes of OCTC and the bar, which is to protect the public. I don't know what that is because I'm just brainstorming right now, but certainly it's one thing that we could put on the board. The other thing that I think it's important for everyone to appreciate, and some of you already do, is this, that there's the alternative discipline program, which has been a huge success for the bar, and we credit the bar for coming up with that program. And that essentially allows people or respondents who have mental health or drug or alcohol abuse issues to essentially go into what's called a diversion program. And it's a remarkable program, and there's been great success with it. A disqualifying factor to get into ADP is a moral turpitude charge against you. And this dovetails in with what Ellen has been saying, and has been a rant of mine for years, is that just because OCTC says it so doesn't necessarily make it so. And the consequence to our clients is really profound. And that is to say, just because moral turpitude is charged, our clients are disqualified from applying for entry into ADP. And oftentimes it's ironically, the moral turpitude clients who are most in need of ADP. And I recognize that they can do LAP, Lawyer Assistance Program, and they can get help that way. But they're the ones that hypothetically, and this is probably a pretty common fact scenario, 45-year-old male who is having marital problems and has no prior discipline, and is having client trust account issues because he or she, or I said male, because he is not focused as much as he should be. That is, in the current system, appropriately a 6106 or moral turpitude charge. And I'm not going to disagree with that. But that in and of itself disqualifies that particular respondent from applying for ADP. And it might be $100. It might be $100,000, granted, but at least there are certain situations there where it's so frustrating on our end, where it's, let's just say, a low level technical misappropriation that involves a moral turpitude violation, and that person cannot get into ADP. So this has obviously been a rant of mine for a while, and probably the whole defense bar. But that's something where I think there's an effective solution there where we could help those lawyers and also be promoting public protection. Judge Wayne.
I think Karen had her hand up first.
Sorry, Karen.
That's okay. I'll defer to Judge Wayne. That doesn't happen here. Go ahead. Well, I guess my question was just with regard to, I mean, I understand the debate over how to charge and whether it's moral turpitude or gross negligence, and really comes down to protecting the public because of the need to perhaps take this attorney out of circulation, either temporarily or permanently, right? I mean, I understand that and why that's an important decision. But from the standpoint of repairing the harm to the public more quickly, I'm just curious, because I don't really know how any sort of reparations are made to the clients through, I think there's some kind of fund that does that, but I don't really know how it works. And I'm just wondering if this delay in repairing the harm to the public could somehow be addressed, even if and then I understand, some of these ideas about also, helping us settle these cases quicker. And those are all good ideas and good points of discussion as well. But I'm just curious about how we might actually get the public what they want, which I imagine is just their money back sooner.
Rachel, do you want to cover that?
Yeah. So we have a client security fund here at the State Bar. Generally, the client security fund will pay out once there's been a finding through the disciplinary process that there's been misconduct. And then the respondent generally has to repay that money as well. But if there isn't been a disciplinary finding, they can still go directly to the client security fund, but the process does take a while. So you can potentially get a payout even without a disciplinary finding or disposition, but that's generally the way the payouts work, is once somebody's gone through the discipline system, then they'll be eligible to receive compensation from the client security fund. Often, and that's a good point, often when we're talking about misappropriations or deprivation of client funds, there is outstanding money. Restitution has not been made. The attorney still has not repaid the money. So those are considerations, again, that we are considering when we go forward with charges. I do want to go back to your comment about the ADP program. Just generally, you're right that an misconduct involving an act of moral turpitude is a disqualifying event, but the rule actually goes further and says that it has to be moral turpitude that results in significant harm to one or more client or the administration of justice. So on your example of $100 misappropriation, I'm not sure that that would be a disqualifying event. So I do think that there are some safeguards built into the process, and that we should really, take heed of those, because there are the majority of cases, I do think, end up where they should be. There are always outliers, of course, but I think the standards, the rules, the case law, all of these things, if we really analyze and look at them, they do provide guidance and process that hopefully, again, we'll have to look at the data, but that hopefully take into consideration some of these things that we're talking about. Again, we're always going to have outliers, but I just point those things out.
Thank you. Thank you for your clarification. Rachel, you had your hand up. Did you want to?
Oh, no, that was it. I wanted to talk about the ADP program, but thank you.
Okay, thank you. And why don't we take Judge Wang and then we'll take our lunch break.
Okay, I was actually going to make the same point Rachel made regarding ADP. I have my own gripes with ADP. I think if we want to talk about that along with resignation with charges pending, I would be happy to open up the discussion with that. But I do allow the attorneys to litigate that issue of whether or not it resulted in significant harm to clients or to the administration of justice. So even if there's an objection on that basis, the parties can litigate that one issue, and then I make the determination of whether or not they are still eligible, notwithstanding the moral turpitude charge. So I wanted to put that out there. And following up on Ed's comment about going to the legislature and maybe moving away from moral turpitude, I haven't drilled down on this, but I believe the ABA has moved away from moral turpitude, and now I think they cast it as serious. And I don't know how other states deal with that. So that might be an idea following up on moral turpitude. And I think the challenge with moral turpitude is that it's defined by case law as well. So we have Supreme Court precedent that brings in gross negligence. So we can't really do away with it. I understand the barriers to settlement with regards to that, but it covers a spectrum. And unfortunately, I empathize with respondents' counsel in this regard. If it ends up being moral turpitude and it does fall in this lower spectrum, you do have the scarlet letter, but I don't know where that clarification can happen. I think the careless reader in reading a stipulation or a decision won't make those distinctions. And I don't know if there's a website, maybe we can find a medium about, changing the website alert or some kind of code. But there are greater, challenges given the case law we have and, where we're all, all players operating in. So.
Thank you. Ellen?
I just want to go back to Karen very briefly and say that, Karen, I just want to make sure that we are all clear. The percentage of discipline cases that involve theft of client funds is small. So we're not generally talking about those cases. If a lawyer has either intentionally, willfully meaning you intended the act but not to violate the rule, or with gross negligence, misappropriated client funds, that's going to be moral turpitude. So we're not talking about that category of cases here. I also want to point out that in order for a respondent to get any kind of disposition that's not disbarment or a very lengthy period of suspension, the lawyer is going to have made restitution of those funds. So in most cases, there's not going to be a delay because the lawyer has not made the client whole. That will have occurred because the lawyer has to do that in order to essentially not be disbarred. So when we're talking about these lower level cases, typically we're not talking about the type of case where a client is being delayed in the receipt of restitution or reimbursement of their funds. We're talking about the other category of moral turpitude where typically that's not going to be the issue.
Right. Okay, thank you, everybody. Why don't we be back at 12:25? So I'll see everybody then.
All right, we are recording again. I think it would be, Lisa and I think it would be helpful if we just make sure that we gather all the information on moral turpitude that the committee wants, so we know exactly what we're going to bring back. So I don't know, Lisa, if you want to share the slide.
Sure.
Just kind of wrap up this moral turpitude conversation. And then after this, if you want to talk about the ENEC and the criminal conviction piece, we can talk about that. And then once we're done with the case settlement, we'll move on to Michelle Harmon and go back to the prevention and support materials for attorneys.
And just so that I can schedule, Michelle, approximately how long will your presentation be?
It should be about 10 minutes.
10 minutes.
Mm-hmm.
Okay, thanks. And so just to clarify, that we have the ENEC discussion, which will be led off by me. Then we go back to case settlement, and then Michelle for about 10 minutes.
Yes, and then we have the final agenda item is on the metrics alternatives to the backlog. And that's going to be presented by Dag.
And Dag, how long will your presentation be?
I don't think it should be any longer than 20 minutes.
20 minutes.
Probably not even that.
Okay, so we'll devote about an hour plus to the case settlement discussion. Okay, great.
Okay. Sean, you have your hand raised.
Yeah, so on moral turpitude, I have a procedural idea. It seems to me that subject would benefit from a smaller group diving into what data to collect and how to collect it and so on. And then Judge Wang has put an interesting idea on the table. An alternative to that effort could be a change to the moral turpitude statute or some kind of other reform. So that's something to think about also. It's sort of a different track, right? Because if we pursued that track, then the data doesn't matter so much, except that we can't be sure that the legislature will agree with us and change the statute. But in any event, what I would propose is we do have to be careful about Bagley-Keene. So I think it would be 3 people. I'd be happy to participate in this and have one person from ADDC, so Ed or Ellen, and one person from OCTC, and see if we can't hash through these issues, because they're kind of wonky. And I think it's not a good use of the entire subcommittee's time to go through that process. And maybe we can bring something back that's a little more packaged and refined for discussion with the bigger group.
Great, I like that idea. And Ellen, you can volunteer now, or I can talk you into it later.
Volunteer.
Great, thank you. And then Melanie, do you want to appoint somebody? How do you want to work that on the OCTC side?
You can put me down.
Great. Okay, thank you for volunteering, both of you.
Oh,
And Sean.
this is going to be a good group. We're going to get this done.
Good idea. Great idea. And Justin, just for my edification, do we need to do something like that via motion? Or is that just something we can do as informally as we just did?
I think I'm not the expert on the Bagley-Keene, but I think appointing a working group doesn't require a motion. But I'm not the expert.
Well, okay, let's do it this way. I move to have a working group formed that will include 3 members, including Sean Salig, Ellen Pansky, and Melanie Lawrence, for the purposes of doing a deeper dive with respect to the moral turpitude issue. Do I hear a second? Come on.
Second.
Okay. And all in favor, say aye. Aye.
Aye.
I think to the extent, Ed, a point of procedure, I think we need to do roll call when we're on a video conference.
Oh, thank you.
Yeah.
Justin, please do a roll call.
Sure. Bell,
Aye.
Duran, let's see, Farwell,
Here.
Jones is here, and yes,
Yes, Gary Farwell is here.
Jones. I see you here, but I don't hear you. Lawrence,
Yes.
Mayorga,
Yes.
Moab,
Yes.
McCall,
Yes.
Pansky,
Yes.
Rosenblatt, Schneider,
Yes.
Salid,
Yes.
Stallings,
Yes.
Judge Wang.
Yes.
Okay, it passes.
Great, good. Congratulations to the new volunteers, and thank you for doing that. Okay, with that, so sounds
So
like
Sean, can I, sorry, one clarifying thing, Sean. So the idea is this working group is they're going to deep dive into the data that we've all kind of requested.
Well, I think we'll discuss with Lisa and whoever else makes sense, what's feasible to do and what we want to look for, what we want to get done. And that may evolve. So Lisa had put the slide up for discussion. So I think that'll be on the table. And then, and we can also discuss, I think, this idea of reform and whether to put that on the agenda. Some proposed modification to the statute or the rules. Because I was intrigued by Judge Wang's statement that the ABA has moved away from the moral turpitude concept, and it, frankly, does have sort of an antiquated ring to it. And maybe part of the solution is some kind of tiered replacement for the moral turpitude concept. That's one thing I learned during this discussion. I'd never thought about sort of lower end moral turpitude versus higher end, but it sounds like that continuum encompasses, is a wide variety of things, and maybe it's too big a category. It could be chopped up into smaller pieces.
Okay, Judge Wang.
I forgot to remind the group that settlement conferences are confidential. So to the extent that we're trying to track the data in terms of what the court suggestion was and what the offer was, I think we need to think about that. I don't know if there's anything wrong with anonymously tracking that data, but I don't know how to tether that to then the public, discipline. So that might be a challenge if that's something we wanted to look at or not.
All right. Justin, is the microphone mine?
Yes.
Okay, so Early Neutral Evaluation Conference, acronym ENEC. We've heard reference to it, and we'll go over it again. My topic is generally using the ENEC for purposes of the criminal conviction referrals. And the position that I've articulated before is a position I will articulate again, is that I think that there needs to be a mechanism for ENECs for criminal conviction referrals. And at this point, that's not how it works. The general understanding that I have now is that when there is a non-criminal conviction referral, then respondents have an opportunity to request an early neutral evaluation conference. Early neutral evaluation conference, or ENEC, is a fancy term for settlement conference. And it's a settlement conference that occurs prior to the formal filing of a notice of disciplinary charges. The significance of it from the respondent's bar in particular is where there are opportunities to resolve a case for something short of public discipline. So you may all recall that there's a spectrum of discipline levels, and one of the light levels of discipline is called a private reproval. And if we stipulate or have a private reproval resulting from a trial, then at that point, it's a private reproval with public disclosure. And it goes on to the membership record and goes on to the membership record for life. If, on the other hand, there is a stipulation of a private reproval prior to the filing of a notice of disciplinary charges, that's private, as between the bar and the respondent. And obviously that there are, at least my perception, probably shared by others, is there a profound consequence when you have discipline on a public record versus discipline that is just between you and the bar and nobody knows. And so there are certainly criminal conviction referrals that end up as private reprovals. I gave this example before, I'll give it again. The classic to me would be the 2 DUI referral. And these are cases that often, without extenuating circumstances, simply let's just call it a 0.08 and a 0.08 that are generally within a 2 or 3 period of one another, where, well, let's make it a little longer. Let's not bring in respondent I. So let's just say 4 years apart, where the second DUI occurred after the probation for the first one was completed. And that, I'm getting into detail, but that's an important detail. So in that scenario, it would be the most likely result in my mind would be a private approval or maybe even an agreement in lieu of discipline. But let's just keep it with the private approval, because I think if you were to graph this out on a bell curve, the private approval would be the most likely result in the hypothetical I just gave you. In the current system, there is not an opportunity to get a private approval. I'm going to qualify that comment. If the referral has been made to the state bar court of that 2 DUI case, there's not an opportunity to get a private reproval. It would be a private reproval with public disclosure. And so what we're talking about in this context is allowing for that respondent in that hypothetical to have an early neutral evaluation conference. So pre-filing, pre-referral to the state bar court, where it's simply a private matter is between the respondent and the bar, and therein potentially negotiating a private reproval, so that it would be private as to the world, but it's still discipline, but it would be private. And so the ENEC for a criminal conviction opportunity, in my mind, would be an appropriate mechanism in order to resolve a case that should otherwise be private. And just to rant for a moment, in particular, where I think this is compelling, is the situation wherein that respondent has expunged both of the DUIs. So nobody knows about these DUIs, and the criminal justice system allows for that. But now you have 2 expunged DUIs. You go through the state bar system, discipline system, it doesn't allow you to have an ENEC prior to the referral. You get a private reproval, which is, let's just say, a nice result in that context. Yet it's a private reproval with public disclosure, where all of a sudden the 2 DUIs that are expunged from your criminal record are out there for the world to see on the state bar website. So that's the essence of what I'm promoting, is in terms of ENECs for criminal convictions. I will further say that our now Attorney General, Rob Bonta, sponsored litigation probably in the last 5 to 6 years, litigation that was passed that allows for, and actually I'm going a little beyond my point, but I'll throw it out there anyway, because it's interesting and it's something that our group could potentially talk about. Somebody had asked earlier, maybe it was Karen or somebody else, about expungements. At this point, there is not an expungement protocol in the state bar discipline system. there is one in the Department of Real Estate discipline system. I handle many DRE cases, and so I'm familiar with this. And there's legislation that was sponsored by Bonta that was passed and allows DRE licensees who have been disciplined to seek expungement. And I think there's a long tail on it. I think you have to have practiced 10 years without any other issues with respect to your DRE license, but at least there's an expungement process, and it's allowed for very low levels of discipline. And I'm bringing up this T2 DUI thing again, because to me, that's the obvious one that would be expunged in a DRE type of process, and an obvious one that should be expunged in a state bar process. So that's my 2 cents generally on why I think ENECs for criminal convictions work well. I also think they work well from another perspective, and that is to say, let's assume in a hypothetical that there is a, let's say shoplifting, okay? Shoplifting, which is, I'm sure it's per se moral turpitude, and I'm not going to argue against that. And so that will necessarily involve some actual discipline. Agree with all that. And what's the bonus of having an ENEC in that context when the discipline ultimately would be public anyway? The advantage to the respondents is a cost advantage. So that's a case that is pretty easily resolved. I mean, the case law is pretty clear on it. There's obviously the defense bar would argue mitigation, but it's the kind of thing that really should resolve in a settlement conference, and almost always will after the case is filed. And this is an important point for those of you that don't practice in the state bar court to know. With a criminal conviction, all the elements of the crime are presumed to have been proven for state bar court purposes. So when we're handling a shoplifting case, we don't get to go into the state bar court and say it didn't happen. It's presumed to have happened by virtue of the plea having been entered or there having been a conviction. So you talk about an easy case that's very resolvable because there's not a dispute as to there might be a dispute as to underlying facts regarding aggravating evidence, but let's just, for the purposes of my discussion, there will be actual suspension on a shoplifting case based on what I just told you. The elements of the crime are proven. The argument there from defense counsel will be the mitigating factors and maybe the surrounding circumstances. But nevertheless, to me, there's an opportunity for a respondent at an ENEC to settle that case and not incur significant legal fees. And so as we're talking about effectiveness on this committee, I think that this really promotes effectiveness insofar as being able to decrease the volume of cases that are going into the state bar court system, being able to get a fair and just result at an ENEC level, and from a respondent's end, being able to save money for attorney's fees and also to save monies for costs. And what does that mean? That means that the state bar has a grid for costs, and the different level of costs is essentially based upon where in the process you resolve your case. And so the cost is greater if you are resolving it the day before trial than it is if you resolve it the day after the NDC is filed. And the cost is even less if there is no referral to the court. So it would be something that would benefit the respondents as well, insofar as having an earlier opportunity to resolve a case in a manner that does not implicate costs. So that gives you the background as to why the ADDC has been very interested in promoting ENECs for respondents for some time now. I said this before, I'll say it again. I have not heard opposition from OCTC, nor have I heard opposition from the judges. And I've spoken to many in the trenches prosecutors. I've spoken to many judges in appropriate contexts. And there's just no pushback. If there's pushback, I'd like to hear it, and we'd be open-minded about it. But I think it's a pretty simple one. Those are my comments. Does anybody have any comments to that? Melanie.
Yeah, I do. Thanks. I think, I guess what I wonder about in thinking about what this commission might do is how impactful this really would be, this kind of change, because really what you're talking about is cases that ultimately would potentially resolve privately. And, the examples that you gave about the 2-time DUI, maybe that's private, maybe it wouldn't be. But the reality is many conviction matters result in some kind of public discipline. The other thing is if the commission wanted to recommend it, it does require statutory change because the office is required to transmit convictions within 30 days of receiving the certified record. So that's why these cases begin publicly, essentially, unlike other cases. I think that we have our some thoughts about the NEC process, which we already shared, and which, I'm hoping that actually part of this commission will be to recommend some changes in the NEC process. But when it comes to convictions, part of the fact of convictions is that they are public themselves. So it's a little bit less of a concern when it comes to conviction matters than regular original disciplinary matters. Although in your example, the attorney has had the convictions expunged. And that's an excellent point. They're still going to live on the State Bar Court website. I guess I wonder about focusing more on those issues related to whether or not cases should be expunged at some point, or whether at least posting them on the State Bar website should be discontinued at some point in time. I don't know. Also, the topic of costs, I think, somebody can correct me if I'm wrong, but I think that the Fairness Subcommittee is looking at the issue of costs in any event. So that may actually impact this as well.
Ellen.
Well, from my perspective, and I venture that I speak for most defense lawyers, I don't agree that the State Bar is required to transmit every single record of conviction to the State Bar Court. And in fact, it has always been the case that OCTC reviews convictions to determine whether or not to refer. And I just want to digress for a moment and give some background, because I'm not sure that everyone on the commission or the subcommittee is aware of this. But in the recent past, I think it was 2018, every California lawyer was required to get re-fingerprinted because there was a problem with the way well, let me go back one more step. Before you become a lawyer in California, you have to go through a moral character and fitness clearing process. And as part of that, every lawyer gets fingerprinted, and the Department of Justice provides the State Bar with records, including criminal arrests and convictions. So it was discovered in the 2000s that those records had not been maintained. So we all were required to get fingerprinted. And as a result of that, OCTC has gone back, in some cases, as much as 15 and 20 years to pull up old convictions. And this has been, number one, a huge source of influx of cases into the system, but it also brought to the forefront this issue about whether or not these very old convictions, many of which have been expunged, involve moral turpitude. So the section that we're talking about is B&P Code section 6101 and 6102. And for example, in 6102A, it says, upon the receipt of a certified copy of the record of conviction, if it appears therefrom that the crime of which the attorney was convicted involved, or that there is probable cause to believe that involved moral turpitude, or is a felony under the laws of the state of California, etc. And then it goes on from there. But clearly in the statute, there is a condition, and that is that a preliminary determination is made as to whether the crime involves, or there is probable cause to believe it involved moral turpitude. And even through today, most times, lawyers who are convicted of their first DUI do not have that conviction referred for prosecution. Lawyers who are convicted of lower level misdemeanors, such as a trespass, disturbing the peace, many lower level misdemeanors, do not have their convictions transmitted to the state bar court. So I'm not of the belief that it would require a change in the legislation. I am of the belief that there should be a preliminary determination along the lines that Judge Wang mentioned in connection with ADP, where the party should have an opportunity to bring this issue before a judge, either at an ENEC or at what used to be called at the state bar court a preliminary hearing, and certainly should have the opportunity to litigate it before the record is transmitted. Because I just want to reiterate what Ed's already said. The State Bar Office of the Chief Trial Counsel unilaterally looks at a record of conviction and unilaterally decides to transmit it to the court. And at that point, in 99.9% of the cases, that then becomes a public disciplinary proceeding. And the lawyer is probably going to face either public discipline or a very expensive and protracted fight. It clogs the system. It costs a lot of money. It has a grave impact on judicial resources. And I don't really see how there's any adverse impact to having something that's either the equivalent of an ENEC or a preliminary hearing when you're talking about a conviction referral, as opposed to what the State Bar calls an original proceeding. Same analysis.
Thank you. Judge Wang, do you want to jump in on this?
Well, to the extent I would not oppose an ENEC for conviction referral matters. I think I don't know how the sausage is made in terms of what OCTC does. I think once it's final, I think they refer it to the review, and the review department doesn't have the discretion to accept or deny it for referral to the hearing department. So what happens is the conviction is sent to the review department, and at that point, there's no facts, actually. We just have the docket, the evidence. Sometimes the complaint's not even there, or the documents vary depending on which county it came from, the year it came from. So that's the only thing the review department operates on. Then it's sent to the hearing department. And then I don't know what, I'm not sure where Ellen's getting the statistics, and maybe we can drill down on that. But as far as I know, maybe Melanie can jump in. I think everything is sent over, even a trespass. I have a trespass, actually. So they're looking, and then the DTC tries to find what the facts are to see if there is moral turpitude or not. So I do think there are a lot of conviction referral matters that do settle early on and could be taken off the docket with an early neutral evaluation. I don't know if there's a cleaner fix, perhaps a change in the rules of procedure where the review department can refer it to the hearing department for an ENEC. I don't know if there's a way of doing that, because the transmittal itself is public, but I don't know if there is maybe a step in between that doesn't involve the legislature. I don't know if that would violate the law. I haven't, taken a deeper look at that, whether or not the review can, review it, send it to the hearing department for early neutral evaluation. So,
Melanie.
Well, to Judge Wang's points and question and sort of how the sausage is made. I don't have the statute in front of me, but Ellen is right in that, we do not transmit all of the conviction cases. So it's very likely that a first-time DUI, for example, would not be transmitted. However, in addition to getting the certified record, we're also getting underlying documents. And that's the sausage that's being made in the interim period. And that's frankly a very, very challenging thing for our office. And it's especially challenging with these older conviction cases, as you might imagine. And so, because what we're trying to determine is whether the facts and circumstances may amount to moral turpitude, even if it's not a per se conviction. So certainly a first-time DUI, while oftentimes those don't ever get transmitted, if in the facts and circumstances there may be moral turpitude, then that would get transmitted. So that's how that works. That's what goes on during that time period.
Great, thank you. Any other comments regarding the ENEC issue? So I have a comment, I suppose, which is this is a nice colloquy, and we are generally agreeing. Question is, as a committee, what should we do? And if this is the easy one, where we're all willing to explore and potentially make a recommendation, what next? And so at least one thing comes to mind, which is to say, if we were to make a resolution as a committee, I don't even know the protocol. I suppose Sean may have to help me on this. So if our subcommittee were to make or to agree to a resolution, then probably it goes to full committee, and then full committee makes a recommendation to the Board of Trustees, which then potentially deals with a rule modification unless it has to come from the legislature. So I don't know how that part works. Sean, maybe you could speak to that.
That sounds right to me. Also, if staff has anything to offer, please do.
I think that is the subcommittees are going to present recommendations to the full committees, and then the full committees will, in I think September, come back and decide on the recommendations, but they may not have the details. So then from those decisions, if the full committee agrees with the subcommittee, there will probably be working groups that go into the details of each of the recommendations, and then it will come back for specific recommendations later on for the full committee to present to the Board of Trustees, and then they can decide whether or not they want to go with those recommendations or not.
Okay, so my initial view is this one's not that hard, and there's no reason to wait a year and a half for us to present this. Again, if anyone can push back on that one, but my view is let's get something done right now. Let's make I don't know about right now this second, because it obviously would involve language that we would probably need to wordsmith a little bit, but then put it up to vote to this subcommittee that then has an entire committee vote, and then send it up to the Board of Trustees. Does anyone want to push back on that? Am I missing anything? I don't hear anybody pushing back. So, and I apologize, but I'm thinking out loud. So it seems to me that that it would be ripe for a motion. And the motion would be something along the lines of, I don't know if it's ripe for a motion, just because I don't have the language to propose with respect to what we're recommending. And if anyone else has the language as they're sitting there right now, go ahead. Otherwise, it probably needs to be something along the lines of, we, the subcommittee, propose that there be a modification to the ENEC process, and this is what we propose. Ellen?
I move that Ed Lear, Melanie Lawrence, and if it's acceptable to Judge Wang, form a working group to work on language to see if a proposal can be made to have some sort of early neutral evaluation conference in conviction referral cases.
Second. Actually, yeah, second. Any discussion? And I guess, Ellen, this is how it's going to work. I'll volunteer you, you volunteer me. Okay, Justin, can we put that up to a vote?
So point of procedure or clarification. So we're just voting on whether to have this working group work this up and bring it back. I mean, we're not affirmatively voting on this, on the policy of changing this, right?
Correct.
Yeah, okay, thank you.
And actually, before we go any further, Melanie, are you fine with that? With being on that working group?
Yes, I'm fine with it.
Okay, good.
Steve has his hand raised.
Steve.
Thank you. We have brought up other issues related to ENECs. I think it may be fair to have all those issues discussed rather than limiting it to the C-case transmittals. Maybe it's appropriate to have a friendly amendment to the resolution.
I would accept that amendment.
Okay, so the motion is that there will be formation of a working group with respect to ENEC related issues, including the issue of criminal conviction ENECs, but not limited to same. So with that motion, do I hear a second on that, a now amended motion?
Second.
Okay. Justin, can you take a vote, please?
Sure. Bell,
Yes.
Duran, Farwell,
Yes.
Jones,
Yes.
Lawrence,
Yes.
Mayorga,
Yes.
Moab,
Yes.
Nakao,
Yes.
Bansky,
Yes.
Rosenblatt, Schneider,
Yes, but I'd also be interested in participating in the committee.
Salig,
Yes.
Stallings,
Yes.
Judge Wang.
Yes, I'll accept Ellen's drafting.
Okay. It passes.
Great. And Linda, let's add you. That'd be great.
Thank you.
Do you have a sense out of the time frame that you'd like the working group to operate under?
Yesterday. So I'd like to have this to the Board of Trustees by September. I don't think this is a really hard one, but I've been wrong. Does anybody think we can't get it done by September? And by get it done, I just mean having a proposal to go to the full committee and then sending that up the chain to the Board of Trustees. Okay, hearing no response, I think it's doable.
Yeah, the only thing I'd say is you're talking about several steps, and the September board meeting tends to be somewhat truncated. So it may get pushed till November. But we can aim for September.
Okay, well,
Just so you know, when you're going through this many entities with the noticing requirements and everything, it can take a while. And if it's an easy item, it would be suitable for September. If it's a hard item, then there's not as much not as much time at that board meeting as other meetings.
So just as a point of order, so I can understand, we have another meeting scheduled in August. We have 2 working groups now that they're supposed to bring back recommendations to the subcommittee that will then put it on to the full committee.
Correct.
Because I'm just timeline, I'm trying to, because we have to notice these meetings. And so I have to, there's a lot of doodle polls that go out, but if this, what these working groups need in terms of information to digest and deep dive in, I'm not sure we're going to be able to bring recommendations back by our August meeting so that the subcommittee can bless them and put them onto the September full meeting. So I'm just trying to do, as staff, logistics, work this out and what the expectations of the subcommittee is.
Well, so I think that knowing that Judge Wang is a problem solver, that she'll have this solved in no time at all. And that we should have language for the August meeting, at least out of this subcommittee, the ENEC subcommittee. And then I would hope that rather than having to convene the entire committee, that we could do it by maybe an email vote to get it to the Board of Trustees by September. That's the goal. That's the aspiration.
Maybe it would be best to let staff try to come up with a timeline, looking at all these different meeting dates, and circle back around after this meeting. Because I hate to try to, I know I asked the question, but I hate to try to work out all the details during this full meeting. But as Justin mentioned, like even the meetings of this new working group you've established, they're going to have to be publicly noticed. So that creates some timing issues. So maybe we can understand that the goal would be to have a recommendation to the board in September and see if we can create a schedule working back from there. And if we can, we'll bring that forward. And if we can't, we'll propose an alternative.
Okay, Leah, I have a question. You just raised something. So can the working group meet without public notice?
I don't think so. I don't know if we have someone from OGC on here, but it's sounding like these are formally established subcommittees of the subcommittee. And so my take would be that they would have to be publicly noticed meetings, but I'm looking for somebody from OGC. I don't see anybody. We can follow up on that as well.
Okay, so my preference would be if it's legally allowed to just have an informal working group meeting, just so that we can do it efficiently and quickly.
Okay.
I'll defer to whatever we need to do. Okay, Ellen, you have your hand up.
I want to clarify for Justin. I don't think the moral turpitude working group is on that fast of a pace because we're still waiting for statistics. So I would say we're talking only about the ENEC subgroup and not the moral turpitude subgroup.
Makes sense. Okay, good. Seeing no other hands up, let's go to the case settlement portion of our agenda.
Well, I think that might conclude the case settlement piece of the agenda.
Oh. Okay. Any other comments regarding case settlement before I move on? Seeing no hands raised, we'll move on. So why don't we have Dag speak as to metrics?
I think we have Michelle Harmon is going to speak about LAP first.
Sure. Michelle, you're up.
Thank you. So Lisa's got some slides. I'm here to talk about the Lawyer Assistance Program and what we offer, and I'll try and focus on the context of what you all are doing in this group regarding prevention. You can see our mission here is on the screen. I don't need to read out loud to you, but we always want to make sure every time we talk about the program that we emphasize the confidentiality, which is protected by statute. None of our information that comes into the LAP gets shared with the discipline system unless somebody in our program signs a release of information authorizing us to do so. And then they always know what information we're sharing also. And we've really made a point of putting that out there every time our outreach person does a presentation in all of the MCLEs, because I know that had been a very big concern at one point, that being a part of the state bar would have a chilling effect on our numbers. And as you'll see later, I have some statistics that our program has been growing really healthfully this past year. So hopefully the word is out there. In the Los Angeles office, we've actually also moved to a different building. So we're not in the main state bar building anymore. So when people were coming in person, they didn't have to worry about running into somebody from OCTC or someone they would be concerned seeing them in the building. And our computer system is separate. We keep our files separate. So everything is confidential. And with the exception, of course, that most of the people that someone would deal with in the Lawyer Assistance Program are licensed clinicians. So if they're talking about hurting themselves, hurting someone else, child abuse or elder abuse, then we need to report to the appropriate authority to protect them or other people. Next slide, please. This is an overview of what we offer. So as I alluded to, we do a lot of outreach and education. We now have one staff member who is entirely devoted to doing the outreach and education. She, as part of her outreach, works with the Office of Communications on our social media posts. So there's frequently information about mental health related issues, wellness issues, for a well-being week in law. We had some posts up supporting that. And she also does our presentations for the competency MCLE, presentations at law schools. They used to, of course, be in person, but now since we've been doing everything on Zoom, she's been able to do a lot of webinars and things remotely. So she's been able to reach more remote counties to speak to their bar associations. And she has now started recently offering a separate one time a month program that's just open to everybody, which we didn't happen before. It used to be that somebody needed to contact her to schedule a presentation for their specific bar association or whatever they were doing, and law firm. And now it's open to anyone. And I thought to bring this up because thinking back to what Randy was presenting earlier about the proportion of sole practitioners who use their service for the ethics hotline, it's the same thing with the LAP. We don't have a number that we can point to on how many are sole practitioners, but anecdotally, the vast majority of people who use our program are sole practitioners for similar reasons for what he's been talking about, not having the safety net and perhaps not having an EAP, an employee assistance program through the firm that can help them, not having health insurance that covers as much. So for the people who choose to come to our program voluntarily, we very rarely see anybody from a large firm. And so these new presentations that she's doing, we're also publicizing through social media. And so she did one yesterday that had over 100 people signed up for it. So we're trying to reach those attorneys who would not be captured in one of those other group presentations. The assessment refers to the first part of interaction with the larger, more intensive lawyer assistance program. Someone will come in, meet with a clinician who will talk to them about their substance use history, mental health history, family, life stressors, work, all the stuff that's going on, and make some recommendations to help them in their recovery process from whatever the issue is. We also offer the professional monitoring aspect. So if they need, for the purpose of admissions for a moral character process, or for discipline, for probation, for an employer who might have somebody come to us as a condition of their continued employment, we will monitor their follow through with the recommendations that we make. If they don't need that, they can participate as what we call a support participant, where we still make the same recommendations. They still have access to our same LAP support groups, but we're not following through to make sure they follow those recommendations, and therefore we don't do any reporting on their participation in the program. The transition assistance service is one of the, I think, lesser known parts of our program. That is the really brief intervention that we offer, which also has skyrocketed in popularity since since people started getting, I think, very stressed out when we all thought it was only going to be a couple weeks of isolation and a couple weeks of just staying at home and white knuckling it. And as people started just seeing that this wasn't going to happen, all the LAPs in the country, from the LAP directors I've talked to, saw a dip last spring in their numbers, and people were hunkering down and they were trying to save money. And now there's been a rebound, which seems to be really strong continuing into this year. The individual counseling, we will refer people to an individual counselor in their area if they need, but also they're doing them all online virtually. And the LAP will cover the first 2 sessions. And after that, they can continue with the rest of, they can continue with that therapist if they want to, with the LAP contracted rate of $100 per session for 2 additional sessions. And then after that, at that therapist's rate that they set. And many of those therapists, of course, are private therapists. They accept insurance and they'll work with people on payment. The career counseling, we have excellent feedback about the career counseling. We've got career counselors who are experienced working with attorneys, working with students who are trying to just start out in their practices or start out figuring out what they want to do in practicing law, what people can do with a law degree if they don't want to practice law and want to find out another way to change their practice or change their area of specialty. They know about the provisional licensure programs, so they're experienced and expect to see people who are in that situation also. Next slide, please. This is a question we often get asked about costs. So costs are really generally not the same for anyone, because for each person in the program, because everybody is doing something different. The core of the program is the LAP support group. And so we refer almost everybody to that group. That is the main thing that we offer that you can't get anywhere else. And that is the reason why we have people who stay in the program for years and years and years. I've been with the bar for 15 years now, and I think there's still 1, 2, maybe people from my original caseload who are still attending their LAP groups because they love it and it's supportive and it helps them. So those groups are $250 per month. Many people, especially those who are needing us to report for discipline or probation or whatever, are doing urine screening for drug and alcohol testing. And actually now we also offer oral fluid testing with at-home video monitored collection, which has been really helpful when people did not want to go to urgent care centers and expose themselves to COVID and things like that. But of course, the cost of those can vary, and the number of times per year that somebody is tested will vary. Individual therapy, we often recommend to people, they can find a therapist through their insurance company, so it might just be a very minimal copay that they pay. We can help people find sliding scale therapists for a very low cost, or they can go ahead and find any provider they want to. And of course, treatment programs, if we're referring to an inpatient treatment program or an outpatient treatment program, the costs really vary widely, but we do try and help people find ones that they'll be able to afford. And the, I don't know if you'd say the good thing or the bad thing about some treatment programs for substance use issues, the cost isn't necessarily, it doesn't match the quality of treatment. So we have people who have gone to Salvation Army programs for free, basically, and get really, really excellent recovery there. And people who are going to very expensive Malibu programs and may get good treatment too, but not necessarily better than Salvation Army. Okay, next slide, please. So these are the statistics I was talking about. Our annual report is on the website if you are interested, but it will tell you that in 2020, we had 141 intakes to the larger lawyer assistance program. So that's the full program with the assessment by the clinician, not those couple of free sessions. This year so far, for the first and second quarters of 2021, we've already had 113. So we are on pace to really surpass last year's intakes into the whole LAP. And for the transition assistance usage, which is the 2 free career counseling and 2 free individual counseling sessions, we had 152 individuals use it in 2020, and already in 2021, 103 have used our program. Next slide, please. One of the other metrics that we look at is satisfaction with the program. This is a survey that we send out to all of the participants in the monitored and the support lawyer assistance program each quarter. It's not a requirement, so it's not something like if we're reporting compliance, if they don't do it, they don't get dinged for non-compliance. But as we all know, the people who choose to fill out satisfaction surveys are not always the people who are the most satisfied. So we've been really pleased that since we've given this survey, each quarter we have met or surpassed our goal of having at least 80% of survey participants report that they either agree or strongly agree that we address their goals and they're satisfied with the LAP experience. Next slide. I think the next slide, yes, is comments or questions. And I just want to add my own comment here is that I was emailing with Randy after his presentation when you were talking about the LOMA, the Law Office Management Programs. And he said that he couldn't find any in the country. And I think maybe that is because a lot of them have been moved to their lawyer assistance programs. I know in Massachusetts, their lawyer, they call theirs Lawyers Concerned for Lawyers, I think, has a robust program. The director in Arizona of their LAP does a lot of law practice management. I think in Oregon, they've got law practice management. So, so just as something else for this committee to know about, that's something that, we don't know the fate of our LAP yet at the bar, but is certainly an area that the LAP has talked about moving into if we are ever going to be expanding our services. So I think I've hit all of the, oh, and one of the other questions that I was emailed is the length of the program. There is no set length. As far as we are concerned, it's a voluntary program. People can enroll when they want to, they can withdraw when they want to with no penalty, which is what the support people in our program do. if somebody is required to be here through quote unquote graduation or successfully completing the LAP, it's a minimum of 3 years of continuous sobriety or mental health stability. So for example, if somebody has a relapse 2 years in, they would still need to stay another 3 years in order to successfully complete the LAP, if that is a requirement of their probation or what the court requires, something like this. So questions? Mr. Lear, I see. Are you on mute?
Yes, sorry. Thank you for the comments, very informative. Michelle, can you speak a little bit to the last point you made about law office management and how that works? And specifically, were you saying that an attorney without drug or alcohol abuse or mental health challenge could go to the LAP program for purposes of help with law office management?
Our lawyer assistance program is more robust than in a lot of states because we have the professional monitoring and we have staff that are clinicians in our program. A lot of the states are more of a lawyer helping lawyer format. So I think in some of the states, you need to kind of be in recovery to be doing it. But if you're talking about in our state, how we would handle it, you don't need to have a diagnosis of a substance use or mental health problem to be in the support part of LAP. To be monitored, we need to have something we're monitoring, right? So we're focusing on supporting a specific issue. But if somebody just wants to come in for support or to access the LAP support groups, they don't need a diagnosis. People come in because they've got stress at work, and so they'll come in and meet with the group for several sessions, and then they might withdraw after getting what they need from that. So if we were to have some law practice management support that we were able to offer, I don't think they would be required. There would be no reason to add a requirement that they would need to have a substance use or mental health problem diagnosed.
Thank you. Any questions or comments?
Judge Wang, I see a hand, although I can't see everybody on the screen.
Judge Wang.
Hi, Michelle. Thank you for everything you do. I think LAP is amazing. Just for the folks who aren't participants or players in the system, can you kind of break down more about the way LAP works for lawyers who are entering, the one-year insight letters, as well as lawyers who are participating who are not in the discipline system, and then the lawyers who are in the ADP program? I think that it hits our prevention issues as well as our rehabilitation issues that this committee is looking at. So I think that would be helpful.
Okay, so there's several parts of that. So please tell me at the end if I don't hit all of them. The word seems to have gotten out that the LAP is a place to go for students if you have problems in your history that you suspect the moral character process will discover. And so we have a lot of students who come in because they want to demonstrate that they are addressing these issues before they even go through the moral character process, before they get referred. So we do get referrals from admissions when they find something. For example, if somebody has a couple of DUIs in their history, that will come up in the process, and they'll refer somebody to us so we can take a look and see if really this is an issue that the person has dealt with and they're fine, or if there's more work that needs to be done. So that's where the insight letters come in. For those people who have been referred by the Office of Admissions, they are usually referred for an abeyance of a period of months, 6 months or a year. And at the end of that abeyance period, they will meet with our, what we call our clinical review team. So it's the clinicians who are involved in working with them, like their coordinator with the LAP, myself, their group facilitator of the LAP groups. Those are all run by licensed mental health clinicians. And we will talk about the insight that they have gained into the issue that they came to us for. And so we will write a letter saying that there's significant, minimal, moderate, and their compliance. The Office of Admissions has really strict rules about what information they can ask about regarding mental health and substance use diagnoses. So we provide them the very barest amount of information so that they can get a sense of where the person is at. And so that deals with the insight. And then so for ADP, the reason you'll see, if you look at our 2020 annual report, most of the people who come to the LAP come in considered voluntary. They don't come in as part of the discipline system yet, because they need to be admitted to the LAP in order to be in the alternative discipline program. So lots of people come into our program saying, either at the very beginning, I had a DUI last night and I know the state bar is going to find out about it. And so I'm coming in now so I can start working on this issue or get my track record of clean tests, all the way until people who are well into the process and saying, well, the judge is telling me to come to you now for an evaluation because maybe ADP is an option for me. And so we will do our, the evaluation is a period of time where they will meet with the clinician, they'll go to the lab groups, we'll get some testing in to see what kind of substances come up that they are maybe not telling us about, or to demonstrate that they are clean, and make a determination if they have a mental health or substance use diagnosis. So for that part, in order to be admitted into the monitoring program and therefore into the alternative discipline program, we need to determine that they have a diagnosis that we can be helpful with. I think that might have hit all of it.
Thank you.
Yes,
Any other questions?
No, Michelle?
I have a couple questions. So the letter of insight, is that only for law students or do you give those to lawyers also?
Only for law students, really only for those who are referred by the Office of Admissions, unless they specifically ask us to, then we can offer it for law students who weren't officially referred. And then we don't provide it to the Office of Admissions though, we'll give it to them and then they can submit it with their application or do whatever they want to with it.
So again, I just want to make sure I understand that last part. So a law student can voluntarily come in on the support side, not the monitoring side, and get a letter even if they were not referred by the moral character department?
Yes, they can come in either support and just do what they want to do and access our groups and get it that way. And they can also be monitored if they choose to be monitored, which is what they would need to choose if they're going to want an insight letter. And if they choose to be monitored, we will go through the same process with them as if basically they were referred by the Office of Admissions. And since they don't have a specific abeyance period that they were referred for, there's no like end date, but after, we want a minimum of 6 months or so to get a sense of them and any progress they might make. And then they can request an insight letter. At the meeting, we'll meet with the clinical review team and issue a letter.
Michelle, I'm not sure that most defense lawyers who represent bar applicants are aware of this. And I'm just wondering if you want to send me something, I'll post it on the listserv. I think this is a wonderful program.
Okay. Yes, absolutely.
Great. Judge Wayne.
Okay, thank you. Michelle, you probably don't have the data point for this, but do you have any information about lawyers who voluntarily enter LAP and never enter the disciplinary system?
Well, I certainly don't off the top of my head. I'm trying to think what would have been in the annual report. The best way to probably gauge that is how many people end up on our caseloads for the mandatory side and the voluntary side. And the voluntary, so we've got staff on both sides of the program, and the voluntary side, as I mentioned, most people come into, so that cycles really quickly. We get people who come in there and then they either leave because they go what they need, or they move over to the mandatory side, which the terminology gets really confusing because they could be monitored on either side, but mandatory meaning they have to be here. So right now, out of the 160 something people we have in LAP, there's probably approximately 100 of them mandatory. So that would be for discipline, probation, admissions, those reasons.
Can I ask a clarifying question? How would somebody be in ADP without being in the discipline system? Not LAP, but ADP. I thought you had to be.
Question for me or for the judge?
Or OCTC. I thought the process to get into ADP involved filing an NDC. You're about to file an NDC. I didn't think you could just go into ADP.
LAP can be voluntary.
Yeah, LAP.
My question was LAP. How many people who are voluntarily
okay,
who never hit the system? So it's back to the prevention issue. That's why I was curious whether or not.
Okay, good. I misunderstood. And I think we can do that data analysis also.
And because the alternative discipline program is the courts program, we may be doing our process, working with somebody, and they tell us, they're going to go into ADP. We don't necessarily even know when that officially happens, because for us, they can still be here working the LAP program, whether they're in ADP or not. So, so we will sometimes get the information from the court, and we'll find out whether they are in ADP. We'll find out when they're not, if they get kicked out of it. But that's not necessarily, our primary goal is to help them deal with whatever the mental health issue is, or the substance use issue is that brings them to us. So we might not even have the very most up-to-date data about what their legal status is with the bar.
Any other questions or comments? No. Thank you, Michelle. Very informative. Let's go to Dag now.
And I'm going to be working off of the PowerPoint presentation. I failed to reintroduce myself the last time that I interjected a comment, but I'm the Chief of the Mission Advancement and Accountability Division here at the State Bar. The research shop is part of my office, as well as the board support and some the Jenny Commission as well. So today I want to talk a little bit about alternatives to the reporting of backlog. On the first slide, the first thing I want to discuss is simply the reason why we want to talk about alternatives to the statutory backlog, which gets to our concerns about the backlog as it's currently written into statute. Business and Professions Code section 6086.15 defines backlog as any complaint that as of December 31 of the preceding year that's pending beyond 6 months since receipt without dismissal, admonition, or the filing of a notice of disciplinary charges. When I first arrived at the State Bar in 2016, I recall that in the Office of Chief Trial Counsel, some of the data analysts created a sheet effective July, it was usually around July 4 or 5, to get to the 180 days, the 6 months, where effectively it was a list of cases that OCTC didn't really need to worry about as much because they were being filed at a point in time when they couldn't fall into backlog as of December 31st. And it allowed them to focus on everything that was filed before that 180-day mark, because that was the focus of the office. OCTC knew that the legislature was concerned about the number of cases in backlog. Staff knew that management was concerned about the number of cases in backlog. And so it created, I think, what we refer to often as perverse incentives in terms of what the Office of Chief Trial Counsel is focused on, rather than public protection in the cases that pose the greatest potential harm to the public. There was a singular focus on backlog. We need to reduce the backlog. And this was a focus at both the institutional and the individual level. This focus created these misaligned incentives. And then as a more technical matter, it's a bit challenging to say, December 31st is the date. So let's focus on that date. And it's convenient for report writing because the report that we submit to the legislature, which reports out on backlog, is due on April 30 every year. And so, it allows us the time to say, okay, as of December 31st, but it's not especially useful in terms of providing a measure of the efficacy of the system. So what I want to talk about then are conversations and some alternatives that we've discussed internally, which are shown on the next slide. And the conversations that we've had internally that have been directed toward providing alternatives to the 180-day backlog standard are these. First, we think that we should have broad categories, and these categories should organize the metrics or the measurements conceptually. These are the three main categories that we're working in at this moment, and they look at caseload and workload. We think that measures of efficiency and operational measures, and also measures of outcomes are useful to distinguish from one another. Um, I, I think it's also important to note, just more generally, that no single measure will ever capture exactly what you want to measure the efficacy of any complex system. And I think that it's important to have these multiple measures because they balance one another. So for example, by saying that we don't particularly like the backlog measure and we think it creates problems, not to say that we don't care about the time to case processing or that we don't think that cases should be processed expeditiously, but it is saying that there's a cost. And so we believe that there are opportunities to report out on the time that it takes to process cases, how long cases are in inventory, but that measure needs to be balanced against other factors. And one of the things that we saw at the State Bar before I arrived, and that I think is somewhat legend at the State Bar, is that there was a time when a zero backlog target was established, and that zero backlog target resulted in the closing of a lot of cases that the Supreme Court ultimately kicked back to the State Bar and said, or excuse me, it was a closure through disposition, a State Bar court disposition of cases with recommendations for discipline. The Supreme Court kicked back to the State Bar saying the discipline doesn't match the misconduct. You guys need to revisit this. So what we really need to do is we need to figure out what these different measures are that balance one another and look at them holistically. And so that's what I think that these three broad categories begin to do. And now I'm going to speak about those three categories and some of the specifics that we've already identified under these headings of caseload and workload, efficiency and operations, and outcomes. Under caseload and workload, we think it's still valuable to look at cases open, the number of cases open, the number of cases closed, the number of cases that are in inventory, and the number of cases per staff. On the next slide, looking at efficiency and operations issues, we think that looking at caseload clearance rate is a useful measure of, are we at risk of developing more inventory that we get handle? Just the number of cases that you close divided by the number of cases that are open gives you a quick overview of whether you have, too many cases coming in to manage, or if you need to be tightening up your operations in some way. The age of cases in inventory, we think, is a useful measure. And then drawing on a measure that the superior courts in California use and that is codified in standards of judicial administration, I think a more valuable measure of the speed of case processing would be to look at the percentage of cases that are closed within certain timeframes. We've been evaluating different percentages of cases closed within different timeframes. What I'm showing here is what the superior courts use as their standard for processing of unlimited civil cases. And it simply says that superior courts are expected to close 75% of their cases within a year. They're expected to close 85% of their cases within a year and a half. And they're expected to close 100% of their cases within 24 months. So we think that modeling a standard for the Office of Chief Trial Counsel along these lines would be valuable. And then on the final slide that I have pulled together here, the final of the broad categories that I listed previously in terms of categories of data that we would provide, looking at outcomes. Disciplinary filings, cease and desist orders, referrals to law enforcement, and assumptions of practice. Somebody who has read into the early literature on reinventing government might object and say these aren't really outcomes, they're outputs. That would be a fair critique. These are outputs of the system. Sometimes it's a little difficult to distinguish between an outcome and an output, but it certainly provides us some quantitative information on the work of the Office of Chief Trial Counsel. And then something that is more akin to an outcome, looking at Walker petitions and the number of Walker petitions filed and the number granted. It's actually a useful measure insofar as it gives us an overview of like, well, did the Supreme Court agree with the action that was taken not only by OCTC, but the State Bar Court? Similarly, the CRU results, and apologize for the acronym. The CRU is the Complaint Review Unit. This is where complaining witnesses can file effectively an appeal, first level appeal following the closure of a case in the Office of Chief Trial Counsel. They may ask for that case to be reviewed. We have a complaint review unit in our Office of General Counsel where attorneys will take a second look at that case and they will ask whether it was closed properly, whether they agree with the decision to close the case, and make a determination. And here, looking at the CRU results, gives us a nice look at, do we see that a lot of those cases are getting kicked back, and are recommendations being made in a lot of those cases for OCTC to say reopen a case? If so, is that a recommendation based on the original case filing? Sometimes people will bring additional information to a request for a review of their case. So these are also important considerations in terms of what, is OCTC closing cases properly? And I think that that's a good measure of sort of, it's an inherent check in the system already there, and tracking that data would be useful to understanding outcomes in the system. So that's really, I just wanted to give this overview of where our thinking currently is on alternatives to the backlog. And that's all I had prepared to present.
Okay, thank you, Dag. Any questions, comments? No. Okay. Justin, I don't have anything else on my list, do you?
That's all the agenda items that we have. If we are towards the end of the agenda, I'd like to present kind of the topics that I heard, and just to make sure that we have consensus from the subcommittee on where we want to focus. We did, initiate 2 working groups, but I just would like to see, let me share.
Before we do that, if I could just say, going back to the metrics discussion, I think you all have been talking a lot about effectiveness metrics during the course of this meeting, looking at questions like overcharging or settlement rates. And so I just encourage, as the group continues to do its work, to think about what we might choose to incorporate, or what you might recommend that we incorporate into the overall metrics for evaluating the efficacy of our system. So for example, if you wanted to look at settlement rates, is that something that we should start capturing as a metric? So I just wanted to make that point. Thanks. Go ahead, Justin.
And actually, before we go beyond that, does anybody have any response to Leah as to metrics that you'd like to capture on a future going basis? Ellen, I'm sorry, Linda first.
Well, going back to some of the things we've talked about today, with respect to, for example, moral turpitude, which was a very big subject, if the bar can capture the data for, the number of cases that have been charged with moral turpitude, whether they're settled, whether they go to trial, that sort of thing. I guess what I'm thinking about is maybe there's a way to break down the different kinds of cases, some that are more mainstream, others that are moral turpitude, to evaluate them in different ways. So like we're talking about here with the courts using these different percentage of cases resolved within a certain amount of time, maybe there should be a goal for resolving moral turpitude cases that's a longer goal than cases that are perhaps like conviction cases or more routine cases. So, and also I just wanted to comment that the word backlog is a very loaded word, and there's always going to be cases that are running through the process, and that's, till the end of time, that's going to keep going on. So I think that word itself is really a terrible one to evaluate the efficiency of the bar or any other organization. So I just wanted to make those comments.
Thank you. Karen.
Sorry. Yeah, I was just curious what data, if any, we capture currently regarding the public's understanding, satisfaction, and perception of the disciplinary process. You know, are we capturing anything from that standpoint? Because this all, what I'm hearing so far sounds like it's pretty focused on sort of cases, which and outcome or output or whatever you want to call it in terms of response for the attorney, but what is the public's, what do we capture, if anything, regarding the public's?
We do send out satisfaction surveys, which also try to get at issues of perceptions regarding procedural justice. So there are surveys that are sent out randomly to samples of complaining witnesses regarding their experience with the State Bar and specifically with OCTC.
But not the public writ large. So it's just complaint witnesses and respondents.
And Ms. Bell, was that what you were focused on, more the public at large?
Yeah, I mean, it's both, right? Like if people don't know or don't understand the process or don't think it, you know, I mean, we're trying to encourage respect for the profession, right? I mean, that's part of the goal. And if people don't, do they understand the process? Do they think it serves their interests? And yeah, I mean, I guess the focus might be more so on complaining witnesses because they've come forward, but I think that'd be interesting to know if people outside of, you know, that also understand and respect the process.
Ellen.
I just wanted to respond to Leah. I guess I had assumed that tracking settlement rates would be part of the statistics that the staff's already looking at. But from my point of view, I think that's crucially important, as well as to determine if there's a way to increase the number of settlements at an earlier stage, both because it saves State Bar resources and because it's, you know, more cost effective for respondents whose costs are going to jump up as the case progresses through the system. But I also wanted to talk about the backlog topic, whatever we call it. I assume we're going to revisit that because that was something that Melanie mentioned in her initial introductory comments. I think it's another area where OCTC and the defense are aligned, that we need to find ways to deal with the backlog. Lawyers don't like it when they sit and wait and they don't know if a complaint's going to be closed or if they're going to have a disciplinary charge. So there's a mutual interest to try to find ways to get cases resolved sooner. So I don't know how the committee intends to circle back to that issue, but we need to do that. And I also, just occurred to me, wanted to throw out that we might want to think about if there's a way to build a pre-ENEC step into settlement negotiations between the respondent and OCTC. And that happens often, for those of you who may not know this, oftentimes it's OCTC in resolving a complaint that unilaterally sends something that's called a resource letter, a directional letter, or a warning letter to the respondent, which is a way of resolving the complaint without imposition of discipline. They're very useful tools. A lot of lawyers don't understand what they mean, but there is already an interim step where OCTC is resolving things with respondents, but I think we could probably do something more in that space before going directly to an ENEC. And so I just want to throw that out.
Thank you. Cynthia.
Hi, is there any way to capture data that shows what is trending or forecasting in terms of allegations of misconduct, such as with the new technology requirement? Is there more with work from home? Is there a more increase in complaints about data breaches or allegations of bias or harassment? If we're talking about effectiveness and prevention, maybe we can get ahead of ourselves and develop some prevention techniques regarding all and any uptick in any allegations of misconduct.
I can speak to that. Right now we are completing a typology of all their allegations that there are about 500 allegations in in our database, and we're trying to, right now we have some really broad categories like performance, fees. And right now we are creating a typology where we take each one of our big broad categories and create some more micro categories so that we can really understand complaints better and understand how complaints change over time. What are the, especially performance. Performance is one of the biggest complaints. And so what is it about performance? Is it not returning calls? Is it not returning files? Things like that. And so, yeah, I think that would be like a really great analysis to do, to see, like, especially in the last year, what has changed over time.
Any other comments? No. Okay, Justin, you wanted to make a couple of comments wrapping it up?
Yes. So I don't know if we can see you see the PowerPoint?
Yes.
Okay, so these are things that I heard throughout the meeting for potential follow-up. In the factors that are impacting case settlement, we've decided to do a working group on the moral turpitude and ENEC. I heard the alternative discipline program mentioned, but I didn't necessarily hear consensus on that. And then I also heard resignation with charges pending, that there could be some efficiencies to that process. But I would like to get, the full committees, whether these are two areas that we want to pursue and bring back to them, or if they're just kind of things that were mentioned in passing. And so I'm looking for some more direction from the subcommittee.
So I know that resignation with charges pending is a topic that Judge Wang wanted to bring up, and there she is. She's raised her hand. Judge Wang.
Yes, I would suggest that the commission explore these areas. Roadblocks and settlement, in my opinion, can kind of be worked out if we take a closer look at eligibility with regards to the aging population with attorneys and resignation with charges pending. And I've given this analogy during settlement conferences, frankly. I have a good friend. His father is in his 80s. He's a heart surgeon. He was still doing heart surgery well into his 80s. And at that age, one day their changes can occur really quickly. And because he had a good support group, they basically called an intervention. So his partners in his medical practice, as well as his family, sat him down and said, look, it's time to consider a transition, right? So they kept him in the practice, and now he's a consultant. He's looking at charts. He's a medical consultant. But he agreed to gracefully kind of change his practice. And for attorneys who are aging, who don't have that support system, frankly, they will end up in the disciplinary system, whereas an attorney with that support system may not. And at least from my perspective, I think we can kind of expand out who may be eligible given those circumstances. I don't think it's fair for an attorney who has been practicing 40 years who has to agree to disbarment when there might be an alternative, a little bit more of a graceful exit. And I do have several respondents where I think the matter could settle in that way instead of continued litigation. And we did bring up ADP, and I would like to explore that as well in terms of whether or not we can expand eligibility or work it out a little bit so that it's a little tracking more what the trend is in criminal practice. Again, I know we can't adopt every type of criminal trend here since our goals are a little different, but evidence-based practice is not necessarily looked at here in terms of the ADP program, but some of the things that the trends in the criminal justice, I think we can take a look at and whether or not it makes sense to incorporate into ADP.
Great. Thank you. Justin, can you continue?
Sure. In the prevention and support resources mandated trainings for attorneys, I heard a reconsideration of the law practice management. And then there was potential outreach to law schools to provide credit for that. And then there was just kind of a general thing. I don't know that there is recommendations on the succession resources, but that might be an area where we would increase outreach on that. So those are the areas that I heard in the training materials. So I don't know if there's consensus on investigating what it would take to bring a law practice management back, since it was sunsetted, 10 years ago or something like that. And Michelle provided the committee that a lot of LAPs kind of do that, or sometimes it's provided by their LAPs. So.
Is that a question or a comment?
Yeah, it's a question to the subcommittee. Are these areas where they would like information to be brought back to so they could form recommendations on this? Or
Karen?
I would just say yes. I mean, I think that I think all of those three things are worthy of further discussion.
Does anybody believe that they're not worthy of further discussion? Seeing no hands, I believe they're worthy of further discussion. Any other comments? No. Okay. Justin, please continue.
We just kind of talked about metrics and settlement rates and allegation trends. I heard of things to kind of look into and bring back to the committee.
Right, and I think an open question for all of us is what metrics would we like to see the State Bar capture in order to assist us with making the assessments that we're making? And so that's a continuing homework assignment for everybody, which is what statistics would you like to see so that you can be better informed. So with that, I don't have anything else to cover. Does anybody else have points that either they would like to cover now or would like to cover at the next meeting?
Gary Farwell speaking again. At some point, well, let me just say, I got on this committee after receiving an email that State Bar had been disproportionately disciplining and suspending Black male sole practitioners. So far in our discussions, that subject hasn't been brought up. It doesn't seem like we're really addressing that. I mean, there's the State Bar obviously could improve its discipline system, yes. But what we're talking about seems to me is just overall. There's always room for improvement, like I said, but in order to find out why Black male sole proprietors, and specifically, but non-white attorneys are being disciplined differently. And I will say that I did speak to an Asian attorney. He had the same issue, that he felt Asian attorneys were being disciplined more harshly. But I don't see that we're going towards addressing that issue. And I would, like to get there at some point, and I'm not sure how we will get there.
So Gary, my preliminary response is that I understand that the Fairness Committee is dealing with that issue. And I'm going to defer to Sean just to have him either confirm or refute that, but that's why we're not specifically talking about it here. Or I'm not going to defer to Sean.
Yes, that's.
I'm here, yes.
Yeah.
That's within that committee's purview for sure. Where they stand with it, I don't know offhand.
Do you want
Okay, I plan to attend
With
there.
someone, maybe someone who knows could, I missed the last meeting of both of these committees and I watched the video for this one, but I haven't yet watched the other video. So I'm a little behind on the other subcommittee.
And
So
I did
that
attend-
is an area where the Fairness Subcommittee has reviewed the Farkas report that pointed those things out. And then Professor Robertson from the Farkas report generated a lot of recommendations to address those racial disparities in the discipline system. And the Board of Trustees adopted some of those recommendations and didn't. And so the Fairness Committee is really looking at that and reevaluating whether or not they should adopt different recommendations or some of the same recommendations that the Board of Trustees didn't look at. So they are very much looking into that issue.
Okay, and I did attend their meeting, and yes, it was brought up more specifically. And the California Associated Cable, for short, has actually met with Robertson last week and will probably meet with him again. But thank you for answering my question. I'll be sure to attend the other subcommittee as well.
Okay, thank you.
Okay, any other comments, questions? Okay, seeing none, I guess we'll end the meeting. Everybody have a good weekend, and we'll see you next time. Thank you.
Thank you.
Thanks, everyone.